Heard y'all made a car.
The floodgates open?
I got a coffee now, man.
Good afternoon. This calls to order the meeting of the House Judiciary Committee. Chairman Stan Gunner is alive and well and is taking care of state business otherwise in the Capitol, so he may or may not join us later. The grandparents visitation bill, if any of y'all are here for that will not be reached today. We will call it as soon as possible, but it will not be reached today because of the Religious Freedom Bill, which has many witnesses here to testify. That is our one and only bill today. Also, I know Senate Bill 68, tort reform, everybody's looking at that. The current version of that bill is online. The current version of the bill, the House Rules Committee substitute, is online. So if you have questions about that bill, please check online. With that, I'm going to call on Chairman Tyler Paul Smith to give us our invocation.
Let's pray. Lord God Almighty, thank you for this day. Thank you for all your blessings, Lord. And most of all, thank you for salvation, that we may have life eternal and life more abundantly here, Lord. We just ask that what we do here will be pleasing to you, Lord. Help us to edify you. Help us to follow your law, Lord. And thank you for all that you do for us. In your name we pray. Amen.
Thank you, Chairman Smith. Senator Setzler, come and tell us about the Religious Freedom Bill.
Chairman, members of the committee, it is a delight to be here in a room I've spent hundreds of hours in a prior life. So good being here with you guys today. Bring before you today, as you know, Senate Bill 36. I have with me Lance Kinzer from the First Amendment Partnership. Lance is a national attorney that has expertise on these issues, worked with legislatures around the country, and we'll let Lance tell you a little bit about himself.
Thank you so much. It's a pleasure to be here. I'm Lance Kinzer, here on behalf of First Amendment Partnership. I served as chair of the House Judiciary Committee in Kansas for 6 years, including during the time period where we passed a RFRA bill. And I'll let the senator lead, but here to answer questions and perhaps provide some additional input to the committee. So thank you, Mr.
And Mr. Chairman, members of the committee, we also provided a packet. There's quite a bit of information that should have been shared with many of you guys. I appreciate any attention you've given to that. We're going to start pretty simply, though. Senate Bill 36 addresses an issue where every Georgian should be free to worship and exercise their faith without unfair federal, state, and local government intrusion. Senate Bill 36, the Religious Freedom Restoration Act, protects ordinary people from unfair state and local government intrusion by exactly mirroring the bipartisan federal law in a way that protects people from unfair federal government intrusion. After the federal RFRA law was passed almost unanimously in 1993, the United States Supreme Court ruled in 1997 that the federal RFRA law only protected people from unfair federal government intrusion and would not protect people from unfair state and local government intrusion. Since then, 39 of 50 states have adopted their own state RFRA laws or seen their high courts adopt state RFRA protections by judicial ruling protect people from unfair overreach by state and local governments. In 2016, Georgia passed a state bill that included language dramatically different than the federal RFRA language, and Governor Nathan Deal then subsequently vetoed that bill. In 2017, our Attorney General confirmed that without a state RFRA law, Georgians do not have full religious protections, allowing a state and local government to infringe on people's faith for any rational reason, a rational basis, the lowest level of constitutional protection, affirmed by our current Attorney General. Since 2021, 8 states have passed RFRA laws, most with bipartisan and many with near unanimous votes, making Georgia the only state in the nation, if we were to talk about partisan politics, with a Republican governor, House, and Senate without state RFRA level protection. And many states, decidedly progressive with Democrat leadership, that also have full RFRA protections. RFRA puts the First Amendment right to free exercise on the same level as the First Amendment rights of freedom of speech, assembly, and press. by creating a simple balancing test. The balancing test that weighs a person's right to practice their faith versus the necessary duties of government. Under RFRA, before government action can force a person to violate their faith, it must show a compelling governmental interest. Not just any reason, but a compelling governmental interest. That it must accomplish that interest in the least restrictive means possible. An example of this, and two specific examples where state RFRA laws have been very impactful, was a young Native American boy in Texas was going to enroll in kindergarten. And the local standards of their school board said that boys couldn't have long braided hair. The parents said, wait a minute, we've got to, is there really a compelling reason for government to make a boy cut his hair whereas girls didn't have to? Parents brought a case, the school board wouldn't work with them. The case ended actually going to court under the RFRA law, and the courts ruled, yeah, there's not a compelling governmental interest from a sanitation perspective or whatever their interest was to say boys have to cut their hairs but girls don't. So the family won the case, and the boy could proceed to kindergarten with long hair, traditionally styled hair, as his Native American religious tradition dictated. On the other hand, RFRA doesn't guarantee a victory all the time, and it's this balancing test where you weigh compelling interests and this least restrictive means possible with government's important interests. A RFRA case was brought in Florida by a Muslim woman. She came from a sect of Islam that said she had to maintain a full face veil except for with her eyes exposed in front of males that were not members of her family. She went to get her driver's license photo, and as is the requirement in Florida, in our state as well, that you have to expose your full face for a driver's license photo. Well, the woman said, yeah, I don't want to do this, and she couldn't reconcile it with a government agency, so she actually brought a case under Florida's RFRA law. And in listening to that case, the court said, there is a compelling governmental interest to remove a face veil for a photograph. There's a compelling interest for that. You're going to have to do that. So she didn't win on the compelling government interest test because the compelling governmental interest, the duty of the government for real ID, won. But the second part of the balancing test, least restrictive means possible. How could the government accomplish its purpose of having her face on her driver's license in the least restrictive means possible? They talked to her, they worked it out, said, you know what, I'm fine to have my photo on my driver's license. I just don't want to expose my face to this big burly highway patrolman in a room full of people. So they allowed her to take her driver's license photo by a female photographer in a private room. That least restrictive means possible test allows these very fact-specific cases to be weighed out, allows the compelling governmental interest of the government to be fulfilled, having your face on a driver's license, but requires the government to at least work with people and see if there's any way they can accommodate the person's religious practice while the government's interest is still being recognized. This careful balancing test is exactly what RFRA does. It does not guarantee a victory for any side. It just requires the government listen to folks and accommodate folks reasonably where they can. These cases are important. RFRA has a 32-year history of success without creating radical or strange outcomes. Unfortunately, in 2008, Kansas did not have a RFRA statute in place. And 60-year-old Mary Steinmetz, a grandmother, who qualified for a liver transplant and was on state Medicaid. She was a devout Jehovah's Witness, a faith that prohibits blood transfusions. Now, she was approved for a liver transplant, but in the state of Kansas, liver transplants could only be done in their university hospital with a blood transfusion. Well, Ms. Steinmetz said, I just can't do that. It may cost me my life, but I can't get a blood transfusion. Now, by her own research, she found out that in the next state over, in Omaha, Nebraska, they actually did liver transplants without blood transfusions. And that liver transplant would actually cost less to the taxpayer than a liver transplant in Kansas. But under the current framework, there was no requirement to let folks move further than 50 miles outside of the state, and they denied her claim. And after a multi-year court battle, back and forth, Mary Steinmetz's medical condition deteriorated to a point where she was no longer eligible for a liver transplant. She died of cirrhosis of the liver in 2014. It was the year before that, as that court case was playing out, that Mr. Kinzer, as the chairman of a Judiciary Committee in Kansas, saw this case and recognized, you know what, if the government had simply worked with Ms. Steinmetz and recognized, hey, this is a sincerely held belief that she shouldn't have to get a blood transfusion, and it can be done in Omaha, Nebraska. Is it really a big accommodation to allow her to go to Omaha, Nebraska, and get a blood transfusion at a lower cost? They would have accommodated her, and she could have got a liver transplant that would have saved her life. This was a life and death issue for Mary Steinmetz. Most people, it may not be life and death, but there are important interests, like the Muslim woman in Florida, that RFRA's balancing test allows to accommodate in fair, balanced, appropriate ways. And all we're seeking to do with Senate Bill 36 is to apply the same standard that applies in 39 states, the same standard that applies at the federal government level to people in the state of Georgia. The bill does nothing more, and the bill does nothing less. Mr. Chairman, if it pleases the chair, I do, just for purposes of illustration, have a couple charts I'd like to show. It won't take very long, but it'll help kind of reinforce what Senate Bill 36 does and how we're trying to strike this careful balance with it. Okay. The first slide that we're going to show here.
Is this PowerPoint?
There we go. This slide is in your packets, but for purposes of taking a look at this, what this shows is it shows the four prongs of the First Amendment. If you consider assembly and petition as sort of one, but religion, speech, press, and assembly. Under current law, you can see that freedom of speech, freedom of press, and freedom of assembly get highest level protections. You know, kind of getting back to con law class, you know, first class rights have what's called strict scrutiny level protection, consistent with the constitutional right. As you all know, second class right, intermediate scrutiny, sort of in between, sort of a statutory right. But most important to understand here is that the rational basis, the lowest level protection, that protection says as long as the government's not just targeting you and picking you out, any reason the government has to do what it wants, it doesn't have to listen to you. As long as they're not targeting you being purely unreasonable, that there's really no duty to accommodate a person of faith. Because of the way the 1997 Bernie case came out, where the Supreme Court said that states have to enact their own statutory framework to protect free exercise and from impacts from state, local governments, cities, counties, school boards, universities, citizens of Georgia have lowest level protection for their free exercise rights. This is the issue. If the federal constitutional protections protected free exercise as they do other things, we wouldn't be having this debate, I wouldn't be bringing a bill, and we'd be fine, because our federal civil rights framework will protect people. But specifically, 39 states have had to act because this is the state of the law with respect to free exercise. Nathan, next slide, please. What that creates for folks in Georgia, if you look at this chart, the next chart shows, again, dark green shows recognition of free exercise as a true first-class right. The places that you get strict scrutiny, full protection for your free exercise rights, all the states around us, and you see those funny little shapes inside of Georgia, those are military installations. If you're on a military installation, you get full rights of free exercise on this military basis. We've got some attorneys here who were attorneys in the JAG Corps. They recognize these things. So on a military basis, if you're on base, you get full protections. But what are those dots? Those dots are actually our state prisons. The 2000 RLUIPA law, the Religious Land Use and Institutionalized Persons Act, provides specific protections. If you're in a prison or you're in confinement, that federal law specifically applies to people even at the state and local level. So if you're a convicted felon in a state prison in Georgia, you have full, strict scrutiny level protection of your rights for free exercise. But law-abiding Georgians do not. That's the almost absurdity of where we are today. That's why we're bringing this bill. This is not a political, this is sort of a lawyer bill. When you look at this, should people in military installations and should people in federal prisons and in state prisons, convicted felons, have their free exercise protected at a higher level than law-abiding citizens? I think it's great that we protect their rights in that way. We should. Institutionalized incarcerated persons should have their rights protected, but so should law-abiding Georgians. Next slide. Next slide I'm going to show you is sort of a national outlay of this. States in gray, like Georgia, are states that have free exercise protected this lowest level of protection. All the states in green have rights of free exercise protected with this highest strict scrutiny level protection. The lighter green are states where that's been ruled on by the high courts, by the Supreme Court of the states, that's read into their state constitutions. These protections are binding in law. States that are the darker green are states that have this enacted by statute. You can see the slightly different color of Wyoming. We had to put that on The Wyoming legislature passed 2 weeks ago their RFRA statute signed by their governor, so we had to update our chart with Wyoming. But you can see millions of square miles around Georgia. You have to go to Colorado in the west and to the northeast to find places that don't have this full protection around us. And you can see red states, blue states, everything in between. This is should not be a partisan issue. In fact, the 1993 Religious Freedom Restoration Act, enacted by Congress, was sponsored by then United States Congressman Chuck Schumer in the House and United States Senator Ted Kennedy in the Senate. So I share this with members and appreciate your indulgence, Mr. Chairman. One other thing I would highlight to you, the power of this balancing test, we talked about how important that is, how you have the balancing test weighing and balancing the powers and duties of government with the rights of people of faith. A little chart in your packets here I would refer to you. The Beckett Religious Freedom Index, a national public interest law group, did polling with Americans, and they shared the compelling interest test, this balancing test with Americans. They said, do you think this is about right? Is it too much religious protection? Is it not enough religious protection? They asked Americans how this balancing test works. And in their poll, they found that 62% of Americans believe that the balancing test is about right. 26% believe it's not strong enough. And that only 12% of Americans think that the balancing test that RFRA provides is too much protection, that somehow it creates an incursion on other basic rights. Mr. Chairman, in your folders I share with you, I've got a memorandum from University of Georgia Law School, University of Virginia Law School. Professor Emeritus Doug Laycock is the author of Federal RFRA, signed this. There are 10 other signatories of this, law professors from Georgetown, Princeton, Stanford, UVA, Notre Dame, Harvard, and others. Their names are on the back. That specifically refers to Senate Bill 36. That what's proposed in Senate Bill 36 is an appropriate standard for Georgia, that it matches the federal RFRA standard very carefully. We've not added things to it. We've not asked for more. We've not settled for less. The language you have before you is the language that's been crafted by Governor Kemp's legal team. This is the bill Governor Kemp will sign, and affirmed by Doug Laycock and his fellow law professors from these universities, that Senate Bill 36 specifically is federal RFRA, provides the same level of protection, nothing more, nothing less, and is appropriate for action by our legislature. Again, Mr. Chairman, I appreciate the Indulgence Committee. Glad to take questions, but again, what you have before you in the LC version you have is the language that passed our state Senate. We passed a Senate bill last year that 2 changes have been made to. When we passed the Senate last year, the governor's legal team met with us and said, we'd like you to make 2 changes. And this is what the governor will sign. That one of the changes was a provision that says you can't sue judges as a result of this. That's part of the federal framework anyway. We wouldn't think about that. They wanted to make sure, as a belt and suspenders provision, you can't sue judges as a result of the RFRA statute. And something that was actually requested by the ACLU of Georgia, we added to it. It wasn't a problem. It's confirmed in writing that this bill in no way establishes an official religion. It doesn't violate the Establishment Clause of the United States or state constitution. We put that language in there at their request, and the governor said, let's just solve this once and for all to make sure there's no confusion about this. We talked about lots of things, lots of provisions. Do we need any litem? None of that stuff was believed to be appropriate to match federal law. That's not in the federal framework. We've asked for nothing more. I think it's appropriate to really settle for nothing less. Glad to take questions, Mr. Chairman.
Thank you, Senator Setzler. The gentleman you brought with you, are you going to testify? Or are you there for legal questions?
Legal questions. I mean, I can speak very, very briefly.
Why don't you go ahead and introduce yourself and speak, and then we'll take questions for both
Lance
of them.
Kinzer, First Amendment Partnership. And what I really wanted to focus on is that this point, that as the bill says on its face in Section 2(3), one of the findings is the General Assembly has determined that the following legislative act adopts the same compelling interest test provided for in the Federal Religious Freedom Restoration Act. This statement of legislative intent, I think, coupled with the actual substantive language of the bill, absolutely locks in what's not necessarily true in every state. I've been involved in all 8 states that have passed RFRAs recently. I'm familiar with the other state RFRAs. Some of them are very close. Some of them pass the RFRA standard and then add significant additional substantive protections. In other states, circumscribe RFRA in some way. And so I think what we can absolutely say with clarity is that as much as any state RFRA that exists in the country, this matches the federal RFRA standard. And I think that's so important for a couple of reasons, primarily because we do have 32 years of litigation history with respect to the federal RFRA. We know how it applies in a broad range of contexts. We know that the federal RFRA law, for example, does not exempt any area of federal law. Every federal statute, every federal reg is subject to RFRA, and we've seen the results about how federal law can still be reasonably enforced, even in a circumstance where you have a broadly protective RFRA law, because the contours of the test itself, the nature of the compelling state interest test and the least restrictive means test don't predetermine outcomes, but do provide a fair standard. And the last thing, because I know a lot of people want to talk to this committee, that I will say is this. What we've seen in states, and I can say this in my own state of Kansas, where we passed a RFRA in 2013 when I was in the position that you're in now, it doesn't result in a ton of litigation. Candidly, we don't have a single appellate court case finding interpreting our state RFRA in Kansas in all of those years. But what we do have is a lot of instances where the existence of this standard in state law has caused folks at the local level, in local communities, to have to sit down and work out workable solutions where both the government's interest and the religious liberty interest of a religious group or a religious individual who would be impacted are able to be resolved effectively. And that's because it tilts the scale enough that it incentivizes the government going ahead and making that extra effort to try to find workable solutions. And really, the best RFRA cases are the ones that never get brought, because things do get worked out collaboratively. And we think that state RFRAs in particular, anecdotally all over the country, it's not that there's a ton of these cases brought, but a lot of cases that never have to be brought because of the fairness of the standard. So I'll just leave my remarks there, and happy to answer questions whenever it would be useful to the committee.
Thank you so much. We'll open it up for questions. I would ask, the pie chart you had, I think that we've seen the other charts, but I'd be glad to pass that around to the committee if you'll pass that over.
I think that's in it's in a slightly smaller version in one of your handouts.
We're working on getting that out to everybody, so we'll just pass that around. Okay, let's see. Representative Evans.
Thank you, Mr. Chairman. Senator, good to see you. When you opened your remarks about some of the reasons that we would need this, the only example I think I heard was about a situation in Texas. Is that right?
There's numerous examples. I just chose to share one or two that I thought were illustrative of.
Do you have anything from Georgia? Anybody from Georgia that's complained that there's something they wanted to do, some infringement they felt that we're seeking to address with this bill?
There are some, but I will tell you, we've been very fortunate in Georgia. You know, this is not being brought in reaction. You know, sometimes we bring bills in reaction to a problem, and the public's in an outcry about this. You know, we've had governors, whether they're appointed judges or elected judges, we've had local governments that broadly respect free exercise in ways that these things resolve themselves. So I'm not bringing this in response to something that happened in my district or some demand. The issue here is, when you look nationally, particularly after COVID, people realized when you had governors that were telling folks they couldn't stand in their churchyards and hold church services. When you saw, for example, in Mississippi, there was a case where a mayor said, you know what, there was a predominantly African American church that recognized social distancing. They wanted to be able to gather together as a body. They parked their cars in the parking lot of the church. The pastor was up front with that. I'll see them with some music, some praise band folks. They tuned their dials and their radios in so they could listen to and participate in the service together. It was shut down by a local mayor.
Do you have any examples of anything in Georgia? That's
again,
the question.
Again, when they were shut down by a local mayor saying you can't do this, they protested, talked to the city, didn't have to go to court, and the city recognized it. We need to let them do this. Those are very specific cases, whether that happened in Georgia, South Carolina, or Mississippi. Those cases caught people's attention. Mm-hmm. That's why we've seen, since RFRA, you've seen 8 states pass RFRA statutes. I could bring you Georgia cases. I think, fortunately, the Georgia cases aren't as indicative of what we've seen nationally. So be happy to share this with you.
But sitting here today, you don't have anything to share from Georgia.
We do. But again, what I don't want to do is pick through the Georgia cases and have them be representative of the broad subset of RFRA cases in the nation. I think the national context of this is probably more illustrative of the kind of cases you see.
No Georgia details that you're willing to share with us today. Is that fair?
Would you like to share some?
Well, I mean, I could talk.
Georgia.
I could talk. Yes.
Not Kansas, Georgia.
Yes. I can talk about an interesting Georgia case that went all the way to the U.S. Supreme Court. Uzogboogum, it was a Georgia Gwinnett College case where there was a student who was distributing religious literature on campus, and he was prohibited from doing that. And he brought a claim that included both a religious liberty component to it and a free speech component to it. And his religious liberty claim was specifically denied because the federal RFRA didn't apply. This was a state actor, not a federal actor. The First Amendment didn't apply to provide strict scrutiny because the view was that this was a facially neutral, generally applicable standard. And so he was left with only the rational basis test under as Georgia protections go. And his religious liberty claim then was booted in that case. He had very good counsel, Alliance Defending Freedom, Religious Liberty. You can read their 61-page reply brief to the motion to dismiss on his religious liberty claim, and you'll see that they focus almost entirely on speech arguments because they knew we've got nothing when the standard is rational basis. Ultimately, that case was, because there was a speech element to it, it was able to advance on speech grounds, and that's how it ultimately got to the Supreme Court.
And he prevailed.
He prevailed on his speech,
on
his speech claims. But that's an example of a Georgia-specific case where, had there not been a speech claim in that instance, he clearly would have lost. That's one example.
That's the case that Representative Evans, the 2017 case I talked about that our current Attorney General ruled on. It emerged in 17. It sort of played out over time. Our Attorney General said you do not have strict scrutiny protections. All you have is rational basis. And in the context of a student who had been consigned to a free speech zone, I mean, he wanted to share his religious faith on campus, and they said, well, stand in the free speech zone. So he dutifully went to the free speech zone. And then in the free speech zone, they said, we don't like what you're saying. Students are complaining about the content of your words. They engaged in content-based discrimination in the free speech zone. And again, his case went up on free exercise and speech grounds. But the free exercise claim by our current Attorney General said you do not have strict scrutiny. All you have is rational basis. And students complaining and the administration saying you can't say that. There's a rational reason. It met the rational basis standard under free exercise. That case is on point. It's on point.
But those students prevailed.
Under speech grounds.
But they prevailed.
No, they prevailed under speech grounds. They definitively failed under free exercise grounds. That's why we're here.
But they were still able to say what they wanted to say because they prevailed on speech.
Because of speech.
Okay.
But the point that's on topic for the committee, if respectfully, is on the free exercise ground, it was definitive. They did not have a free exercise claim.
Do you have any examples of anything in Georgia where someone was seeking to exercise religion that a lot of times it's going to include speech, so you're going to have that, but do you have any examples where there was not speech involved, and an example where someone was literally not able to do what it was they were trying to do, whether they prevailed under speech or some other way, somewhere where someone's rights they felt like were actually stopped in their tracks?
Let me ask this
in
question.
Georgia.
Let me ask the lady the question. How many examples do we need to share?
Well, you don't get to ask me questions, Senator, with all due respect. I want an answer to my question, though. Do you have any Georgia-specific examples where somebody was trying to do something in an exercise of religion and they were stopped from doing it?
We do have some. I want to ask, how many examples do we need to bring today?
Well, I would like to have at least one.
I shared one.
No, that person prevailed. I want one where someone didn't get to do what they wanted to do.
Respectfully, this is not a bill about speech. This is not a speech bill. You understand very well that there are oftentimes different prongs to a case. The fact that there was a speech prong that they could pursue was the nature of that case. He's fortunate for that. But on the free exercise grounds, will you agree? Can we both agree that on free exercise in the Azug case in Georgia Gwinnett College, our Attorney General ruled, and it is as a matter of law, can we agree, that his free exercise claim could not proceed beyond rational basis protection in that case? Can we agree on that?
I'm looking for an answer to my question, Senator. And the reason I'm asking is not to pin you down, but I'm interested as a lawmaker in making sure that we don't have holes in our laws, where if someone is trying to do something that is a legitimate exercise of their religion, that they get to do it. And it may be that we have speech protections, or we have, some other bundle of right protections that protects that exercise. And if we have that, then we don't need to worry about creating another lane for protection. But if we have a hole where there's legitimately not protection, I'm interested in finding that. And so that's the reason for my question.
Well,
and if you don't, and it's fine if you don't, and I'm not saying there has to be 100 examples. I'm trying to find one example in Georgia of somebody that was trying to have a legitimate exercise of religion that wasn't able to do so. Whatever the reason that they might have been able to do so, I'm less interested in.
Yeah.
And if you have that example, share it. And if not, we can move on. And
We will, but I share your goal of finding holes. Can we all agree that if there's holes in our law that we need to cover?
Mr. Chairman, if there's not an answer to the question, just tell me and we can move on.
I think to have a fair discussion, isn't it true that in the Zubinam case in Georgia Gwinnett College, that the hole in our law is not a hole of free speech? The hole in our law is there is no protection, there's no strict scrutiny level protection for free exercise. Can we agree on that? And is that not a hole?
I haven't read the case. Senator, do you have a specific Georgia example of something that was stopped? Just yes or no?
We've got some.
But you don't have it here today.
I mean, one other case,
Committee members asked me to ask you to identify yourself again. We know you're from Kansas.
Sure.
And you and I
Yep.
have talked.
Lance
So,
Kinzer, First Amendment Partnership.
Thank you.
There's one other case. It's a 11th Circuit case, Keaton, Keeton, versus Anderson Wiley. It's an Augusta State University case, involved a woman who was in a counseling program, and she was ultimately removed from the counseling program, or wasn't able to advance in the counseling program because her views, they said she wasn't able to prove that she was multiculturally competent, basically because of some of her religious views, and wasn't able to advance. She brought a claim both on free exercise grounds, under which she only got rational basis review for the same reasons in the prior case we talked about, but in that instance there was found not to be a speech component, and in that instance she didn't prevail, and that case did go up to the 11th Circuit. The 11th Circuit said that the government action there on free exercise needs only to survive rational basis review, under which it's presumed that the Constitution and the burden is on the plaintiff to prove that it is not rationally related to a legitimate government interest. So that's one example of a specific Georgia case where someone brought a case for free exercise and speech, was found not to have protections under either, and ultimately she wasn't able to continue in that program because her religious beliefs conflicted with what the school believed.
And Mr. Kinzer, what school was that?
So that was Augusta State University.
Augusta State. Okay.
We get a site.
Yeah, I've got the link to it. It's Keaton v. Anderson Wiley. It's an 11th Circuit case, and while we're sitting here, I'll get you from the site.
And on the Supreme Court case, Chike, Chike is the first name, Uzagubunam, Uegbunam is the party name, Georgia Gwinnett College or Board of Regents.
That's right.
Georgia Attorney General represented the state up there. Justice Thomas wrote the majority. It was 8-1. In favor of the individual against the state, and legal fees were paid to the plaintiff, and then the state, of course, paid the state's legal fees to lose 8-1 at the Supreme Court.
It went up on the question of whether they could continue to pursue a claim for nominal damages after the university had changed their policy.
All right, we have a lot more questions from the committee, so let me start with Chair Lady Silcox.
Thank you, Mr. Chair. Thank you so much, Mr. Kinzer, for joining us today.
Yeah.
And I believe you said you were from Kansas.
Yes.
Very good. And I understand that Kansas does have a civil rights accommodation law.
We do have a civil rights law, yes.
Very good. Georgia is one of 3 states that does not.
Right.
So if Senator Setzler's interested in closing holes in our laws, then I think to appropriately address this fully, we would need to pass a civil rights accommodation law.
Well, my response to that would be that, first of all, there are a wide range of state and local civil rights laws that exist in states with RFRA. So, for example, Mississippi and Alabama, who similarly don't have comprehensive state civil rights laws, have RFRA. Alabama, it was actually, the RFRA standard was actually embedded in their state constitution. Mississippi has it by statute. Then there are other states, for example, Rhode Island, Connecticut, Illinois, New Mexico, Iowa, that have
I appreciate that, and
statewide statutes
there are
that are
local.
broad.
There are some
Right.
local jurisdictions in Georgia that have local such accommodations in civil rights
And just
ordinances.
okay.
I got, yeah. Great question, and I'm glad to ask it, because we were thinking about laying this out and presenting this in the original presentation. One thing, when you think about the robustness of protection that people have for civil rights in general, outside of this free exercise hole, if you will, the federal 1983 process is very robust protection of civil rights. In fact, if you bring a case and you prevail on its merits, you get attorney's fees. It's automatic in the system. Many cases you get damages. I mean, the federal system is more generous than our state system is from a plaintiff's perspective. The protections we have outside of a free exercise context are very robust in the federal setting. It's because of that the state of Georgia has never seen fit to put in place a parallel system. Because you put in a parallel state system, you've got, well, we could do a federal claim or a local claim. It creates chaos there. You have venue shopping that can happen. It creates arguably more litigation if we have a state level statute.
So then, why do we need a state RFRA statute?
Because thank you for the question. But for free exercise, the federal civil rights framework protects people's rights with strict scrutiny protection. It's only for free exercise. With respect to state and local governments, the folks don't get strict scrutiny. That's the Bernie v. Flores case, 1997, said specifically.
There are people in my district, Senator Setzler.
Let's let the senator, let him finish.
All right.
The Bernie v. Flores case, 1997, said specifically. It's indisputable legal fact. It said the federal protections, the civil rights protections, do not apply to free exercise claims with respect to state and local governments. It's that case that leads to the states having to pass these state RFRA laws. The only reason we're doing that is for that reason. If that wasn't the case, if free exercise was protected like all these other civil rights, we wouldn't have this bill because we'd have the protections. I mean, the robust protections at the federal level are way greater than what we could pass at the state level anyway, so there's not need for one. But for this free exercise circumstance, with respect to state and local governments created by the Bernie case. That's it. That's the reason.
I would still contend that we don't have the protection that we need with the civil rights in the state without that law.
And if I could, to my friend from Sandy Springs, with respect to local statutes, one thing we're very careful in this bill to do, this is a down the middle sort of balanced bill. We've tried to take a balanced approach from the very beginning. You know, some states, Tennessee, Arkansas, others, have frameworks that prohibit local ordinances from elevating civil rights interests higher. We have 18 municipalities, local governments in our state that elevate specific rights at a higher level than the statewide standard. Our bill allows that to stay in place. It doesn't try to go after those. Doesn't try to take those out. But nor does
there are jurisdictions that have none.
Well,
We have a patchwork.
there's a statewide standard, and 18 jurisdictions have elevated specific interests higher. This RFRA bill doesn't seek to take those out. This RFRA bill works in parallel with those. In those communities where those interests are raised to a higher level of legal protection, this RFRA law, which provides full protections for people of faith, the governmental interest will be higher in those communities because those communities have acted specifically to elevate that to a higher level. So the balancing test in those communities gives more weight to those specific interests. We think that's okay. RFRA travels well around the state. But just as we're not trying to take those out in any way, we have no intention to do that, nor should RFRA cede themselves and allow locals to wipe out religious rights. It allows the balancing test to apply equally, and in communities that have those ordinances, those interests are weighed stronger, and we're okay with that. This bill's down the middle and allows that to happen as it should.
Representative Oliver, I know you've heard this bill or version of it before, so.
Thank you, Mr. Chairman. I apologize for being late. I'm in other committees trying to figure out when the votes are. Is it your position that we should determine the legal standard of strict scrutiny versus rational basis based on this poll taken by Beckett Religion Freedom Index? Is that
No,
your position?
It's our position.
And you offer this to us as argument that we should consider this poll?
It's context. It's just context.
What does that mean, context?
Well, the legal argument, Representative, that we made was, Madam Chair, is the case we made that from the Bernie v. Flores case, 1997, there's this unique incongruity, this hole in our federal civil rights framework.
And how people feel about their civil rights is relevant to our intellectually honest discussion of the law?
Well, we're having a discussion of law, Madam Chair, but what that represents, nothing more, nothing less, than when the compelling interest test is explained to people and asked, does this feel right in terms of the way?
How it feels is what you want us to consider.
It's context. It's not a legal argument, but it is context. I think it's just important to understand.
Any follow-up? Chairman Smith.
Thank you, Mr. Chairman. Good to see my fellow SoCon graduate from that other school in South Carolina.
We were foes in a former life, by the way.
We have plenty of time these days because
Yeah.
none of us made it to March Madness.
Yes. His schools. Yeah. Even though I love my former member of the House, I do not have many purple ties, and I wasn't going to wear one today either. But one of my questions, though, Senator, would be, and if you covered this already, I apologize to the audience here and those witnesses, but this doesn't just protect the Presbyterians, the Baptists, the Free Will Baptist, or the Left Foot Baptist. This protects Jews, Muslims, Zoroastrians, Rastafarians, Buddhists, pagans, any religious belief that, is recognized by the United States government, correct?
It does, and in fact, if you study across the nation the circumstances where RFRA has been most meaningful to people, it tends to be minority religious faiths that are not well understood by public decision makers, that might draw into their ordinances and their laws specific accommodations. It's pretty well known, for example, that the Roman Catholic Church, they use wine in communion, so there may be an accommodation for communion wine for minors. That might be well known and drawn into a law. But people of minority religious faith, sometimes the policymakers don't know about those things and could pass generally applicable laws that impact them. It tends to be people of minority faiths that are helped by RFRA. And that was, in many ways, what prompted RFRA in 1993 was the impact that when government recognized they could impact people of minority faiths in meaningful ways, there was a recognition to make sure that they were getting this balancing test, that the government's interests could still be fulfilled, but it would happen in the least restrictive means possible. It really is for those that in many cases RFRA's brought.
So whether you're a Mormon or a Muslim, it could apply to you as well?
That's correct. Yes, sir.
Thank you.
Representative Crawford.
Thank you, Mr. Chairman. And my question is for the gentleman from Kansas. You referenced the Kansas law as it pertains to discrimination, and as I'm reading it, it is a broad, it covers broadly, it acts against any discrimination on race, religion. My question is that if we don't have the same type of broad legislation in our state, could your bill as passed be discriminatory and then also preempt local ordinances, as you mentioned?
So let me say two things. That first of all, it absolutely does not preempt local ordinances. Secondly, in the absence of a state anti-discrimination law, RFRA doesn't somehow become more powerful and create this generalized right to, in the abstract, go out and try to enforce a religious liberty interest. If there's no government action for RFRA to bump up against, RFRA doesn't apply. It does nothing. And so RFRA doesn't make it, even if you were to argue that the existing federal anti-discrimination laws that apply in Georgia, to which RFRA applies at the federal level are inadequate, and we need state laws. The absence of those state laws does not make RFRA a more powerful tool. It doesn't turn it into a tool to discriminate. It just means that since the state is not acting to do anything affirmative in those spaces, there is no government action, therefore there's no RFRA rule. Now, I think the question of whether there should be, what anti-discrimination provision should exist in state or local law is a completely legitimate conversation to have. It's just that this RFRA bill doesn't make it more difficult to reasonably enforce the local anti-discrimination laws that exist, and I think there's tons of case law in other states with RFRAs and local anti-discrimination laws to show that, and passing RFRA in the absence of a statewide Civil Rights Act does not somehow make religious interests more powerful, because there's nothing for it to butt up against. It doesn't apply in purely private instances. It's only activated where there's some government action. So that would be my basic response, if the senator would say.
As I shared earlier with Chairman Silcox, when we drafted it specifically to be balanced and neutral. Those 18 local civil rights ordinances we specifically left alone. There's 3 states that have preempted those from being effective. Utah did that, Tennessee, Arkansas. No municipalities may enact local ordinances that are different from the state standard. We left those alone. One state, Texas, yields to those, that no matter what those say, the religious interest has 0 weight. That's not the federal standard either. The federal standard takes these interests and on a case-by-case basis weighs these. Because in some case you may have a government interest that may be, by analogy, 2 inches high versus a religious interest that's 20 feet high. I mean, as these things are weighed, you can't exempt things. But in this balancing test, we want things to be ruled on by public officials and courts fairly and apply the balance. But we specifically did not It does not preempt those 18 local statutes that exist or any that could be put in place in the future. And we specifically do that for a reason.
And, all right, Senator Setzler and Mr. Kinzer, shed light on this. I've got LC 44 2920 ER. That's the version we've got. It looks like that's what passed the Senate.
Yes, sir.
What portion of the bill addresses that, or are you saying that y'all didn't have anything that struck those local ordinances?
Yes, sir. What we're saying is that the absence of any language that that speaks to, and in addition to this, you can't have a local ordinance, or a local ordinance can't be broader than the state anti-discrimination law. But the absence of that language allows those to continue in force.
Representative Crawford, did you have a follow-up?
You asked my follow-up of where that is in the bill.
Yeah.
We were on the same wavelength. Representative Evans, I see you've got another question. Does anybody else have a question before we take a second round? Anybody? Any questions? Representative Evans.
Thank you. And it's just a quick follow-up. Thank you, Mr. Chairman, on the Keaton versus Anderson-Wiley case. I looked up the case, and the only 11th Circuit opinion I can find is one denying a preliminary injunction against this for the benefit of the committee. I'm reading while we're doing this, but best I can tell, you've got a counselor that for religious reasons had certain feelings about gender and sexuality, and LGBTQ students felt like they were not being treated fairly in her class, and so the school put the professor under a remediation plan, and the professor was trying to have the remediation plan lifted, and so she moved for a preliminary injunction. The Southern District of Georgia said no, and she appealed that to the 11th Circuit, and the 11th Circuit affirmed the decision not to enjoin anything. It wasn't the 11th Circuit decision that I've been able to find wasn't a final decision on the merits. The only final decision I've been able to find was on the merits was a Southern District of Georgia opinion that granted a motion to dismiss. And I just want to make sure I found everything. I don't really need you to comment. I just want to make sure I found everything, because I want to read the case in full, because it's about 40 pages. But best I can tell from my preliminary reviewing is that the idea of whether there was state protection versus federal protection didn't come up, and I just want to make sure I'm looking at the right case.
So the only clarifying comment I'd make is that she was a counseling student, not a professor.
Okay.
But the way the case evolved, you can see the claims that she was able to bring based upon the state of Georgia law only got her
Well,
to rational basis.
I want to respect the committee's time. I'm following up. I read the case different than you, but I want to make sure I'm reading everything that you know about and I'm not missing something. I've got
think
one
there's just
11th
one
Circuit
11th
decision
Circuit opinion in that
and then the
case.
Southern District of Georgia opinion that
I think that's correct.
granted the motion to dismiss. Okay, and then I'll report back to the committee about what the court actually decided. Thank you.
And again, Mr. Chair, to the question, two cases in which, on point, rational basis review is what's provided under Georgia law, and that's the issue, is you don't get strict scrutiny as you might other rights. It's specifically only rational basis here in Georgia.
All right. I do not see any more questions from the committee for Senator Setzler or Mr. Kinzer. Last call. I want to make sure everybody gets everything out on the table. All right. No more questions for y'all. Thank you for coming.
Thank you, Mr. Chairman,
All
Mr.
right.
Committee.
Thank you
very much.
We have a lot of people signed up, but I see one elected official who has another committee meeting. So unless we have any other elected officials who have a committee meeting, I'm going to let Representative Panich speak to the bill to let her get to the next meeting.
Thank you, Mr. Chairman, colleagues. As you know, because I've said it a million times, I'm the only Jewish member of this body, of the entire General Assembly. So I have a special responsibility to speak out when I believe minority rights are being challenged. And this bill absolutely challenges it. And the easiest way to know that is because when confronted with a proposal to add an anti-discrimination provision in this to make this actually in line with federal law, it has been rejected time and time again. So what does that tell me? That tells me that this is going to be used as a sword and not as the shield, which is what the federal law intended it to be. I cherish religious liberty as a core American value, and this legislation threatens the community it claims to protect. I know what it means to need protections for religious practices, but as written, this bill will become a tool to those who want to discriminate against not just my faith, but other minority faiths and other people like the LGBTQ community. History has taught the Jewish community to be vigilant about laws that create imbalance in religious protections. Because right now, the Jewish community is pretty strong in Georgia. We feel protected in Georgia. But we know that can change on a dime. We're seeing things in other places, in other states, like in California, where a man wore a hat with a Jewish star on it, and the owner kicked him out and said, there are no Zionists here. We don't want Zionists here. This law in Georgia would allow the same behavior if somebody felt like they had a sincerely held belief, and that was compelling enough. Jewish religious practices like kosher slaughter or Shabbat Sabbath observance could receive less protection than majority Christian practices. And these are not hypothetical concerns. They reflect the lived experience of minority faiths when broad religious exemption laws lack proper safeguards, and this one does. Religious freedom should never come at the expense of equal treatment under the law. Judaism, and I know Christianity, emphasizes Christian justice and dignity for all people. That's why major Jewish advocacy groups have consistently opposed this version of the state's RFRA without explicit non-discrimination protections. We saw what happened in Indiana. When their RFRA passed without anti-discrimination safeguards, the backlash was swift and severe. Then Governor Pence ultimately had to amend the law to specify it couldn't be used to discriminate. And Georgia, if they're going to enact RFRA, needs to do the same. The solution is straightforward, and the failure to accept it tells me what this bill really is intended to do. All it needs to say is that it cannot be used to discriminate against any Georgian, including LGBTQ individuals and religious minorities. A single line codifying that discrimination is harmful and that there is a compelling governmental interest in preventing it would transform the legislation. Just last session, this legislature came together in a bipartisan support of HB 30 to protect the Jewish community, especially after October 7th. I am eternally grateful for that. You listened to us then. I'm asking for you to listen to us now. This isn't about opposing religious freedom. It's ensuring that my religious freedom and the freedom of all Georgians is protected equally. I urge you to vote no on this bill as it's written. Thank you.
Thank you, Representative Panich. Before you go, you mentioned amendments a couple times, and I think we got the 10 Commandments somewhere on campus, and they don't have an SB or a HB in front of them. So everything else in this committee gets amended, and it gets, amendments are proposed after we've heard presentation from both sides. HB 30 was a great bill, but it was amended here in this committee. This committee perfected it. So regardless of what the Senate or 30 other states have done, this committee is hearing it, and decisions on amendments will be made after we have heard and read and considered it carefully. So don't talk in the past tense about that. That's something that is, very much why we're here today.
Thank you so much,
yeah,
Mr. Chairman.
You
Thank
bet.
you.
All right, let's see. We have a lot of speakers signed up, so let me call on Mike Griffin. Mike Griffin. And we had a lot of people sign up, and if you did not sign up and you want to be heard, we will give an opportunity at the end. So we will take that up. We would ask you to be succinct. As a judge from South Georgia said, the mind can only absorb what the backside can endure. So please keep in mind that we are hearing a lot today. So please, everybody, be succinct. We will hear from supporters and opponents who've indicated support and opposition interchangeably. I'm not going to do one first and then the other. So we're going to hear from both sides as we go throughout today. Mr. Griffin.
Being a Baptist preacher, I've heard that a lot.
Right. Amen.
Only what the backside can endure. My name is Mike Griffin. I'm the Public Affairs Representative of the Georgia Baptist Mission Board. And Mr. Chairman of the committee, I appreciate the opportunity. I've been doing this a long time. I've got probably 2 or 3 T-shirts from this. I started back in 2014. I see former Representative Sam Teasley's in the room, and I'm good friends with former Senator Josh McCoon in dealing with this for a while. And I will say that Georgia Baptists do support wholeheartedly this legislation. I got a message from Georgia Life Alliance from Claire Bartlett that they do support the legislation as well. I will mention that we have passed 2 resolutions on the Religious Freedom Restoration Act, one in 2014 and one in 2024. And Georgia Baptists represent approximately 1.4 million Georgians and up to 3,500 churches. And if you put the Georgia Baptists and the Catholics together, we represent well over 25% of the population, and they're going to be here today as well. So we do support this legislation, and it's a basic premise, and that is that the RFRA restores the original intent of the First Amendment of the United States of America, of our Constitution. And so, that's basically the premise of what this is on. And so to be, in essence, practically against it would be that you're not for the First Amendment as it originally was brought in our nation. While many opposing this legislation accuse the RFRA of being discriminatory, it's simply not true. The legislation is not about protecting any discrimination. A matter of fact, back in 2014 through 2016, when Senator Josh McCoon was here, he offered $1,000 that he would give to any charity if someone could demonstrate a situation where any invidious discrimination ever happened because of Religious Freedom Restoration Act. And during that time period when he was here, he never had a single case that was brought up before him. So when you look at this legislation, a RFRA protects people of faith from government intrusion and not being forced to violate their First Amendment right of conscience. So it restores the original intent of what the First Amendment in the Constitution is all about. In other words, it restores people of faith to the same standard that you have in freedom of speech, freedom of press, freedom of assembly, and even in freedom of speech, we all recognize that in the freedom of religion, as in speech, there has to be a balancing test. I mean, you can't stand up and scream that there's a fire in a theater. If there's not one, you're going to cause problems. So, you have a right to say something, but you can't say something like that. And that's true on the religious freedom issue. We want to make sure that there is a proper balancing test there, and that's what this does. And I'll close with this. In 1993, President Bill Clinton, who signed the RFRA into law, here's what he said. He says, "But let us never believe that the freedom of religion imposes on any of us some responsibility to run from our convictions. Let us instead respect one another's faiths, fight to the death to preserve the right of every American to practice whatever convictions he or she has, but bring our values back to the table of American discourse to heal our troubled land." So we would strongly request that the committee please consider supporting this legislation. We appreciate Senator Ed Setzler and his willingness to submit this again, and we thank him for his effort on it. Thank you, Mr. Chairman.
Thank you, Mr. Griffin. Let's see, we do have a question. Representative Holcomb.
Thank you. What is it that you can't do today that you think you'd be able to do if this were enacted?
Well, when I kind of agree with Matt Sharp with Alliance Defending Freedom when he spoke last year at our Pastors' Day at the Capitol. He talked about when it comes to legislation like this, it's almost like a sprinkler system. You don't put it in while you have a fire. You put it in before you have one. And so I tell people there's probably two words that describe why we're not having major issues. And I do have 14 cases that happened back in 2014. I'll show them to you later. But my point is, you want to put up a sprinkler system before you have a fire. And I said there's two words to describe why I don't think we're having major issues right now. And that's the word Brian Kemp. And he's not King Kemp. And I think his policies and what he's doing over our different agencies is very respectful of those of us that even may agree or disagree on various issues, but he is very much about not being discriminatory, about protecting each people's rights of what they believe on various issues. And I think that's been great that we have such a great governor, who I met with him in 2018. I've known him for probably over 20 years. But one of the commitments that he made to us was that he wanted to see a Religious Freedom Restoration Act, but he wanted to make sure it was a 93 version that didn't have any extra stuff added onto it, and he wanted it to be of what the original intent was.
Right, but
and
that's
I'm
not my
thankful for
question.
his
My question is,
leadership.
what can you not do today that you would be allowed to do under the law? Can you give me any
There's
examples?
not anything we can't. The issue here is as we get closer and closer to people disagreeing with us, governments could begin to pass laws that infringe on churches' rights to hire, what to do on different facilities, how to do different events. I mean, we've already had some NDOs passed in Tucker and in DeKalb. I worked with ADF on knowing what that information was, and it does seem like there's some things starting to kind of creep in that might begin to try to dictate some things. Hasn't happened.
Okay.
Hasn't happened. That's why we need a sprinkler system now. So if it ever does happen, we will make sure that there's a strict scrutiny standard that's applied, and that the government has to have a very compelling reason of which we would all agree with.
Okay. So I think what I heard you say is that your concern is over the adoption of non-discrimination ordinances, NDOs, I think is the phrase that you use.
I mean, Tim Gill said in 2017 it's time to punish the wicked.
I'm sorry?
He said it's time to punish the wicked.
Okay.
I mean, he said that. That's not me. He said that in 2017 in the Rolling Stones magazine. So apparently there may be some people that want to attack people of faith for their religious beliefs because they don't agree with them. But I'm just saying that was a statement. That's not happening here. Is it coming? Could it be? Could there be an infringement of the government on people of faith or 501c3s? Could that come? It could. But you know what? If we have a RFRA that is based off of a 1993 RFRA, you know, going back to the original one that we had and the original intent, there's no reason for anybody of any faith or of no faith at all, or even disagreement on gender issues to have any reason not to be for a RFRA.
Okay.
Because we respect each other's right to believe and carry that out. We just don't want to force other people to have to participate us on things that we don't agree with. But it's not about discrimination. It's not about being prejudicial. We held a press conference here in 2014, and you know, Dr. White, who was our executive director, said Georgia Baptists are not for the LGBT community being mistreated, being prejudiced, or discriminated against. I mean, we stood up against that, saying, no, that's not what we're for. We're not trying to do that. We're not against them not being able to have homes or get jobs or be able to participate in these things. Ours is we just don't want to have to be forced to have to participate in things that has nothing to do with them. It has to do with our biblical convictions. And it's not about being discriminatory or being prejudiced toward anybody or treating them different, mistreat them at all. No, we don't want that. You know, I'm friends with the LGBT community. Jeff and I are friends. Jeff and I know I love him. We might not agree on some things, but I've said this before, so I may get some growls. But I'm just saying, I do. I love the LGBT community. I don't agree on some things. I have some friends that I've talked with and spent time with, and I've literally had, and I'm just going to get blunt here, so y'all probably run me out. But, you know, I've talked with folks, and they're like, you know, Mike, I would never force you to have to participate in something you didn't believe in. I wouldn't make you have to participate in some ceremony that I wanted to have if you thought it was your religious right not to do that. I'm like, well, that's awesome. You have a tremendous respect. We have respect for one another. Even though we may not agree, I'm not going to force them. And you know what? I've got friends who said, well, I wouldn't force you to either. We can love and respect each other. We can disagree. And just because I disagree with you does not mean I hate you. And just because I agree with your right to disagree with me doesn't mean I agree with you either. But if I disagree with you, that doesn't mean I don't love you and that I don't respect your view. That's what we want. We want fairness. I'm preaching. I need to stop. Chairman, Mr. Chairman,
Thank you, Mr. Griffin.
All right.
All right. I will say this. Take a look at that list of cases that you may have with you, and if at all possible, if you're willing to circulate that, I think that'd be helpful.
Well, I mean, and Senator Teasley, Representative Teasley, you remember Attorney Crumley, you know, we had some, I know we looked at some cases that never, they actually, I think they were all won, but I don't think we had a RFRA. Those cases would have never even come up because they would have had to have had a strict scrutiny standard. And they were all taken care of, though, by the way, and not any of them had anything to do with any LGBT issue either. Nothing with that.
Representative Evans, we got another question. Mr. Griffin, you
All
got another question from Representative. And by the way, I'm getting questions. Hey, witnesses are getting questions. I mean, that's the way we do it here normally. If we want to dispense with that for all witnesses, we can do it. We got like 16 or 17 people signed up. I think having a hearing, we might as well have a hearing. But I'll let y'all, let the committee think about that. But we do have a question. So go ahead.
Thank you, Mr. Chairman. And Mr. Griffin, again, I'm interested in making good law. And if somebody shows me a hole in our law, I want to discuss how we might fix it, if we can do so in a fair way. And so if you've got cases, I want to see them. And it seems like to me, if you've got cases, you would want to share them. Now, if you're afraid that we'll look at them and find out that they don't say what the paper says they say, that may be a reason not to share it. But if you say they show a hole in our law, I guess I would ask you, why wouldn't you want to share it with us?
Well, there is a hole.
Well, can I see the cases?
39 states have a RFRA. We don't. So here is a place where there is a hole, meaning a hole by way of the standard that you're going to use if you have to deal with any of those types of cases.
Well, by hole, I mean people that have tried to do things in the exercise of religion, and the courts have told them they couldn't. And if those cases show that, I'd like to see them.
Yeah,
and if they don't, then I would say just hold on to them. But it's up to you.
Yeah.
But I don't think it's right, Mr. Chairman, for a witness to come in here and say they've got cases that say a certain thing but refuse to show us the cases.
Yeah.
So it's up to you.
We work together on that.
Any other questions for Mr. Griffin? All right. Thank you for coming.
Appreciate it.
You mentioned Mr. Crumley, Jonathan Crumley, and you said ADF, that's Alliance Defending Freedom. If anybody wants to phone a friend to gather that from that attorney, I know he's knowledgeable. But next witness, we've got Rabbi Michael Bernstein.
Two preachers in a row. You are pushing it. I am the rabbi of Congregation Gesher LaTorah in Alpharetta, Georgia. I'm glad I didn't go immediately after Senator Panich, because obviously I share a lot of her feelings about the Jewish community and the reason why we oppose this bill, and very strongly so. This is, as Senator Panich said, and as I'm sure everyone here knows, it's a very difficult time to be Jewish in the world. And there is anti-Semitism on the rise. And there's a reason why I feel more comfortable in this country than leaving Israel out of the equation, any other country in the world. And that's because there's a constitution that protects my right and my religious freedom. But as a minority religion, my rights are more protected by the Establishment Clause than the Free Exercise Clause. Of course, I need a country that says any religion, including mine, can do what we see fit as a religion. But any minority religion knows that what makes this country special is that it's not possible to establish a single religion as one that has a greater say, that has more of a purchase to who our country is and what our country is about. And it may be, I think as Senator Panich alluded, a time when we find many friends in different faith communities. But a bill like this is not about the immediate situation. It's not about who our friends are now. It's about the health of the Constitution. And it's about the maintaining of what makes this country a unique country, not only for Jews, but for Muslims and for others who are in minority religious positions, without recognizing that there's a reason why our Constitution is careful about what religious freedom means. Absolute religious freedom for how you practice, and absolute protection from infringement by someone whose practice is different than yours. Absolute protection. And if we don't have that protection from infringement, then the entire Constitution becomes meaningless in terms of my religious protection. Because someone can say to me that in their exercise of their closely held religious beliefs, they don't particularly think that Jews should be able to do this or be able to do that, or Muslims. And then, of course, the LGBTQ community, I know, and I'm not a member of that community by identity, but by close associations and by my heart and by what I believe my own faith tells me is the definition of the image of God in every single person. Friendship is nice. Being loved is nice. But having the right to get married, having the right for your gender to be recognized, having the right to be the person that you are is not up for debate under our Constitution. Especially if it's a religious reason that compels somebody to say, no, my religion does not believe the way that you understand your gender or the way that you understand your sexuality. We cannot believe it as much as we want, but the government cannot be in a position where it is more concerned with the purpose of someone else's ability to infringe, to discriminate. And I'll say one other thing. The phrase compelling interest, it really strikes me that a government that has become less interested in protecting everyone cannot be the one to be relied upon to say, yeah, we're going to have a compelling interest to protect every single kind of person. This is an important moment for us to recognize that the people in protection who need protection are more and more the minority faiths and those whose very existence and very way in which they live in the world is denied by those of other faiths who want to be able to expand their ability to infringe and to discriminate.
Thank you, Rabbi. Any questions? No questions from the committee. Thanks for coming.
Thank you.
Frank Mulcahy.
Thank you, Mr. Chairman. This one. Thank you, Mr. Chairman. Okay. Members of the committee. I'm Frank Mulcahy. I'm Executive Director of the Georgia Catholic Conference, representing the Catholic Bishops of Georgia. I do have got a long list of folks this afternoon. I will try not to repeat what others have already said. I have a couple of points that I do want to make. One is I was here in 2014 or 2016 when the bill passed both houses and Governor vetoed it. I don't think that's much of a precedent for us today. That bill was much longer. It had a lot of different bills all mashed into one bill. I know the governor was concerned that it would be harmful for bringing business into Georgia, but the bill was, I shouldn't say this, but it really wasn't that well done. That's why I think what Senator Setzler has done is give us a good short bill, which really does copy the federal bill. It has the balancing. I understand the issue of minority religions, and as somebody said, I think if you look at most of the cases that are out there on their federal RFRA, it is they're not being brought by the so-called mainstream religious groups. They're brought by minority religious groups, some of whom have practices which are not considered mainstream. Someone raised the question of the Catholic Church, serving wine to minors. There is actually an exception in the statute about distribution of alcohol to minors for religious purposes. I was not involved in getting that, but somebody thought enough 20 or 30 years ago to get that into the code. I don't know what we would do today, but that's the concern we have is what we are doing might be interfered with. I understand Representative Evans' questions about what about Georgia, and I don't have any examples from Georgia. But we are seeing across the country a lot of concern about some of the things that the Catholic Church is doing, which are not very popular, such as providing shelter for migrants. There was litigation pending in El Paso over a shelter which gets a lot of migrants right across the street, right across the river from Juarez. And that's the thing we would be concerned about. Several years ago, we had the issue of the Little Sisters of the Poor and the fact that they had an unpopular position, which was they were unwilling to provide a health program which included contraceptives or abortion. That was not very popular, especially under the Obama administration and looking at exceptions in the Affordable Care Act. Those are the kinds of things that create a risk and a concern for us. And even to say, well, what about today? How are things today? The federal law has a provision which says that RFRA is to apply to everything unless the Congress puts an exception in for a particular bill. And it's been tried several times, a number of times over the years, has never gotten into the final bill. But nonetheless, there is a concern, and a current concern, I guess. I have a letter which I took off the Catholic Bishop's website. I'd be happy to share it, Mr. Chairman, if anyone would like to look at it. And it doesn't say anything that will surprise you, but there are 43 names of organizations who write to the leadership of both the federal House, Congress, and the Senate saying, don't put in exceptions, please. As I said, it gives a little bit of a history here, but it's nothing that Mr. Setzler, Senator Setzler, said earlier. However, if anyone would like to look at it, Mr. Chairman,
Absolutely.
I'll be happy to give it. You make copies of it. I can get other copies. Yeah, it's on the website, but you're willing to have it. I guess the last thing that I would say is I think there were a lot of reasons why that bill did not pass in 2014 or 16. And I have to say, I think Governor Deal probably did the right thing in vetoing that particular bill. But this is a nice, I hope, a nice, simple bill. One of the things the folks in there mention is the importance of the balancing test, and I think Senator Setzler has covered that pretty well. So anyway, those are my comments.
Thanks a lot. The Sisters of the Poor case you mentioned, that's the Hobby Lobby case from 2014 or so.
No, the Hobby Lobby and the Little Sisters of the Poor were two different cases.
Two different cases. Okay.
They cited each other, as it sort of bounced up to the Supreme Court, but they're two different cases.
Okay, both about health care.
Yes, that's correct.
All right. Any questions for Mr. Mulcahy? Representative Holcomb.
Yeah, I'm going to ask the same one, which is there anything that the church can't do now that you want to do and that you would do if this was changed? Because the standard would change from rational basis to compelling state interest. Can you give us any examples?
I don't have anything that we have tried to do and have not been able to do. I don't have an example of that, no.
Okay. And would you agree with me that the 1993 statute, that's complemented by a whole host of federal statutes to include the 1964 Civil Rights Act, which Georgia does not have in our law, correct?
That's correct.
All right, thanks.
Any other questions? All right.
Okay.
Thanks for coming.
Thank you.
Thanks for coming. We got the pastor, the priest, the rabbi out of to testify first. So and let me at this point let me just say everybody's heard from all these witnesses. There's been a lot that's been said so far, very eloquently, for and against. Don't feel obligated to make the same points. If what you are here for has already been covered, feel free to come up, say who you are, who you represent, and say that. So brevity sometimes can be the most persuasive thing. So with that, next witness is Nika Iwulano from ACLU.
Actually, Mr. Chair, she was not able to make
And
it today.
that's okay, and I see there are multiple ACLU representatives, so feel free to, whoever the next one is, come on up and just identify yourself. And so Ms. Iwulano is not here anymore.
That's correct.
Okay, all right.
Okay, awesome.
Please introduce yourself.
Yes, sir. Good afternoon, Chairman and members of the committee. My name is Sarah Hunt Blackwell. I'm the First Amendment policy advocate with the ACLU of Georgia. And I'm here testifying in opposition to SB 36. I'd first like to take some time to thank Senator Setzler for including the Establishment Clause in this version of the bill, which was not included in last year's version. We really do appreciate that inclusion. However, it does not completely resolve our issues with this bill. Our religious beliefs and our expression of those beliefs are some of the most sacred aspects of humankind. Yet, throughout the history of humankind, we have seen some of the worst atrocities committed in the name of religion. In the U.S. alone, religious extremism has been used as a basis to massacre Native American tribes, enslave African people who were forcefully brought to this country, relegate Black Americans to second-class citizens during Jim Crow, unfairly surveil and target Muslim Americans in the 20-some-odd years since 9/11, shame women for wanting to have control over their own bodies, restrict LGBTQ+ communities from accessing services and opportunities, prevent wives from leaving their abusive husbands. The list could literally go on. We've heard just this afternoon that a counselor at Augusta State attempted to discriminate against LGBTQ+ students due to religious beliefs. With a history that demonstrates how religion is often weaponized against minority communities, it seems to be a reasonable conclusion that SB 36 would provide a mechanism which exploits and perpetuates discrimination. I will also add that Georgia residents may already pursue claims of state infringements of religious expression because the First Amendment protections extend to state governments in the same way that they apply to the federal government per the Due Process Clause of the 14th Amendment. In that regard, Georgians do not suffer any holes or gaps in the protection of their religious expression rights. The real issue at the crux of SB 36 is the standard by which these infringements would be analyzed in court. As Senator Setzler mentioned, courts analyze potential First Amendment infringements under one of three standards: strict scrutiny, intermediate scrutiny, and rational basis, with strict scrutiny being the highest level of review and rational basis being the lowest. The point of this tiered system is, in part, to treat egregious, targeted infringements with higher scrutiny. The system essentially recognizes that all situations are not the same, and not all infringements are targeted attacks against someone's religious expression. Instead, RFRA attempts to force every situation to be analyzed as if the infringement was targeted and intentional, requiring the highest level of scrutiny in every single instance. The existing tri-tiered system is the appropriate balancing test, not the single standard of analysis required by this bill. To close, SB 36 would do far more harm than good, and we should be doing everything we can to prevent extremists from contorting religion to align with their damaging and discriminatory perspectives. That includes maintaining this tri-tiered system of review and steering clear of strict scrutiny requirements. We urge you to please vote no on SB 36. Thank you for your time, and I'm happy to answer questions.
Representative Holcomb.
Thank you. Appreciate what you had to say, and you concluded by saying this would do more harm than good. Can you give us some concrete examples of how you would see that playing out?
Absolutely. Just again to reference the Augusta State case, there was a counselor who was trying to essentially not provide support to LGBTQ plus students, and that counselor was not successful, in part because RFRA, because the court did not analyze that counselor's case at a strict scrutiny level, and instead analyzed it at a rational basis level. Had it been the opposite, the outcome may have been very different, and the court may have said, "You're right. This goes against your religious beliefs, so you don't have to offer counseling services to LGBTQ plus students in the same way that you offer them to anyone else."
Okay. Any other examples you can think of?
Yes, there are quite a few. Denying the ability for landlords to deny LGBTQ plus people housing. Again, there was a case just in Indiana where a father tried to use RFRA as his defense for beating and strangling his children, and saying that his religious beliefs allowed him to use corporal punishment as he saw fit. Churches have tried to use RFRA as a defense against why they have certain people on staff who have sexually abused children. There are a lot of instances here.
Okay, thanks.
Thank you.
Any other questions? All right, thank you.
Thank you.
Mac Parnell.
Good afternoon, members of the committee, Mr. Chairman. Thank you so much for taking the time to hear this. It's an honor to be with you all today, and thank you so much for considering this important piece of legislation. My name is Mac Parnell. I'm the Executive Director for the Georgia Faith and Freedom Coalition. The Georgia Faith and Freedom Coalition has been in this fight for a long time, supporting our most basic fundamental rights. We are in full support of Senate Bill 36. We have a letter in your packet more fully detailing our support, and thank you so much for your consideration.
Thanks a lot. Any questions from Mr. Parnell? All right, thanks for testifying. Let's see, Jeff Graham.
Thank you, Mr. Chair. I am Jeff Graham. I'm the Executive Director of Georgia Equality. We are a statewide organization that advocates on behalf of the estimated 265,000 people who identify as lesbian, gay, bisexual, and transgender, as well as all people living with HIV in the state of Georgia. I don't want to belabor the point. We've talked a lot about the issues. I appreciate the sensitivity that this committee is already showing about the concerns of discrimination. I'm sorry that Representative Oliver had to leave, because I did want to say that I appreciate that this is about law and facts and data, but it is also about how people feel. And at a time when last year there were 24 bills introduced in the legislature that we feel were specifically targeting members of the LGBT community for discrimination or adverse action, restricting our access to health care, restricting our ability to thrive as other Georgians can thrive. So far this year, 12 bills have been introduced that we feel offer similar animus towards those who identify as members of the LGBT community, those who provide health care to us, our family members, our parents that support us. It is something that we are very concerned about. I do want to say that I have great respect for Mike Griffin as well. I personally and organizationally, we do have great respect for people of faith. That is why we work so closely with so many faith leaders. It is a critical cornerstone of what it means to be an American. We have worked with a number of the 18 municipalities that have enacted non-discrimination ordinances, and we always encourage them to put in specific religious exemptions to make sure that those ordinances do not violate people's religious views. I know personally that the elected officials in both Tucker and DeKalb County spent months, frankly, I think it could be argued spent years looking at the issue of religious exemptions before they ultimately passed unanimously their non-discrimination ordinances. And so I do have the concerns of the Religious Freedom Restoration Act in Georgia that I have always had. That basically is that without a statewide civil rights law to balance this, that those non-discrimination ordinances may be vulnerable. And that folks who don't live or work or worship in those areas that have non-discrimination ordinances may be vulnerable as well. And so I encourage this committee, please do not move forward Senate Bill 36 without putting in those protections that would protect all Georgians who fear discrimination. Thank you.
Thanks a lot, Mr. Graham. And while you're stepping down, and or any questions for Mr. Graham? No questions for Mr. Graham. The next witness we'll call up, let's see, Bishop Garland Hunt from Gwinnett County. And while you're coming up here, let me just say, please get word to Representative Oliver. She got a positive shout out. Also, if anybody's got President Bill Clinton's number, let him know. He got invoked in the House Judiciary Committee today. So, all right. That was quick. Y'all let me know if you get through to President Clinton. All right, Bishop Hunt.
Thank you. Thank you so much. I'm fighting these allergies, so excuse me for that.
And traffic from Gwinnett County.
And
you
traffic.
You made it.
Goodness gracious. So anyway, I'm Bishop Garland Hunt. I senior pastor of the Father's House in Peachtree Corners. I also serve as the president of the Douglas Leadership Institute. I'm actually one of the few people that was born and raised right here in Atlanta. I was born right here and grew up in the 60s and the 70s. I grew up with the whole aftermath of the segregated South. My age is kind of the children of the civil rights movement. So I live close to the Kings and Abernathys and all those. And my parents experienced the white-only fountains and the restrooms and the dining facilities. So I'm very aware of our history. But I am here to say, though, that I believe this fight for religious freedom is more critical than even the civil rights legislation. And the reason I say that is because religious freedom is an inalienable right from God. And I really believe that when you compare civil rights and inalienable rights, we have to look at, for me, what stands most importantly is what the biblical truth is. I also, by the way, I'm probably really dangerous here. I'm a lawyer also. So I'm a preacher and a lawyer. But let me just say this. I know we've talked about it a little bit before, but for the sake of my time, the RFRA provides a strict scrutiny test for all courts. Namely, the government may not have a burden to restrict the person's exercise of religion unless it can demonstrate a burden of restriction for with a compelling state interest. Now we all know that. We all know that the whole idea of what does you have to prove. It's the same thing if a person is innocent in court. The government has to prove beyond a shadow of a doubt that there's some level of intention. So we're talking here about a compelling state interest that Georgia, as opposed to 39 other states, will not protect my religious freedom to just minister the Bible or preach the Bible in certain environments. So that is a concern. I think that you mentioned earlier what are the concerns that we don't have if we don't do this. I'm really concerned right now because there are municipalities in other states and other places that will call some of my language just from the Bible that may be considered hate speech. Or I may take my Bible out into a public square like Chike did at a government institution here, and he was refused. And the problem with that particular case is that because it had to go on speech, because there was not enough here to prove in rights for religious freedom to help him to even talk about religion. So they had to go with free speech and not religious freedom. Georgia is one of the few states that you can't even argue religious freedom. But with the I guess you used to call it in law, scintilla of evidence. I think we call it here with reasonable faith. So I am very concerned about my state. And so when you think about that, religious freedom is more than just allowing for diverse religions to coexist. We have to have that. And an opportunity to attend church is actually the ability to act on your convictions of your faith. And today, people of faith are being censored, facing demands to violate their conscience. Right here in this Capitol, I don't know if you guys were here, early in the mid 2015 to 17, I can't remember exactly the year, Chief Cochran, we had a major big thing here because the mayor restricted him from writing a book. I got a fear if something I write could be in the wrong environment, and they required him to actually put his religion at the door because he could not have a conviction, and he lost his job as a result of it. But we do not have in our state a compelling state issue of compelling state interest for the state to come against him. Now, the city of Atlanta had to actually give him over $1 million because it was wrong. But again, it all goes back to what is our strength that we can have in order to fight for what we believe. It's not discrimination. It's all about standing for what you believe and what can allow us to have the freedom to believe in that. If I don't have 15 cases or 13 cases or one case, I should not have to have a Rosa Parks in order to have civil rights legislation. It's the same thing. I should not have to have a major issue in our state in order to have the protection of my religious liberty based on the First Amendment. The national standard is clear that the United States says they have compelling state interests, but Georgia does not. And therefore, I have fear of that as a man of God in this state. Thank you.
Thank you, Bishop Hunt. Any questions for Bishop Hunt? All right. Thank you for coming. All right, let's see. Pastor Matthew O'Rear of St. Luke Lutheran.
Mr. Chair, members of the committee, thank you. I will be brief. I'm the Reverend Matthew Daniel O'Rear. I'm a husband. I'm a theologian. I'm a pastor of a Lutheran church here in Atlanta. And most of all, I am a proud native son of the great state of Georgia. But I'm here in unyielding opposition to Senate Bill 36. Let's be clear. Religious freedom is not under attack in Georgia. This bill does not protect faith. It elevates religious beliefs above the rule of law, allowing faith to be weaponized, to divide, to exclude, to discriminate, and to erase. We've seen this before. Faith in this very state justified slavery. Faith in this very state defended Jim Crow. Faith was wielded to deny women the right to vote, to control their own bodies, to stand as equals. Faith has been used as a club against the LGBT community, against immigrants, against Jews, against Muslims, against anyone who dares to exist outside of a narrow vision of what's righteous. The sponsor of this bill says it's about religious freedom, but religious freedom is not under attack in Georgia. It's protected by the First Amendment, by the courts, by the Constitution of the great state of Georgia and our nation. What is under attack is the right of everyday Georgians to live free from government-sanctioned discrimination. And make no mistake, this bill is not neutral. It has consequences. People will suffer. People will be harmed. And people will die. Some of you may say that's not our intent, but history has shown us intentions do not matter when the impact is harm. Georgia doesn't need a law to protect that which is already free. Faith does not need government permission to exist, but faith does require justice. So I ask you, will Georgia be a place where faith is a force of love and justice, or will you write into law the same justification that has been used to oppress, to exclude, to harm, and to erase? Reject Senate Bill 36. Stand for justice. Stand for all Georgians. Thank you, Mr. Chair.
Thank you, Pastor. Any questions for the pastor? All right, thank you.
Thank you.
Next witness, Paul Smith.
Thank you, Mr. Chairman.
Thank you.
My name is Paul Smith. I'm Executive Director of Citizen Impact. We represent churches and Christian schools all across Georgia. Many of you participated just a few weeks ago in our Pastors and Ministry Leaders Day, where we had pastors and other ministries here from all over the state of Georgia. I'm here to support this legislation, and I thank Chairman Setzler for bringing it. I'd like to share just an anecdote. One of our church ministries in Valdosta, Victory Baptist Church and Christian School, when Hurricane Helene struck that area very hard back in September, I believe, they coordinated with, I think, county government and provided some 5,000 meals to their community over the course of the next week or so. When they were providing those meals, no one was asked before they were given a meal what's their faith affiliation, what's their political affiliation, what's their sexual orientation, what's their immigration status. They worked with the local government to provide meals for those who are in need. Our ministries that I represent work in the community to help assist people with food insecurity, with housing insecurity. We coordinate with local public schools to minister to at-risk children, and many of our churches work with young women in unplanned pregnancies to assist them through that challenging time. And our churches are filled with foster care families who help alleviate the strain on our overburdened Georgia foster care families. This is without respect to affiliation or connections. And we would like to see those ministries continue. We would like to see our churches be able to minister in that way. We are asking for just this bipartisan RFRA protection that's in the majority of the states already. And we would ask that you would pass it without any amendments, without any carve-outs, without any exceptions.
Thank you, Mr. Smith. Any questions for Mr. Smith? All right, thank you for coming. Reverend Dillard.
Good afternoon, everyone. Good afternoon. Thank you, Chairman. I appreciate your time, and I will do my best as a Baptist preacher to be brief. I am Reverend Dillard. I also am a native of Georgia. I am a product of Georgia Public Schools, a recipient of the Hope Scholarship, if we remember that. That might date myself a little bit. I might tell on my age. I am also the faith coordinator at Sister Song, but I'm also a local pastor. I've been a children's pastor previously, so part of what I do in my role is birth justice, and we have been specifically focusing on fertility justice, and so that's really what I want to speak to in reference to this bill. This is one of my major concerns that I particularly want to highlight, because I think many things have been brought to the forefront, and I don't want to kind of belabor some of the points, but as a local pastor, I'm particularly concerned about what I'm experiencing with my congregants and what I'm seeing among your constituents here in our state. Our law has not quite caught up to IVF. It has not caught up to what I'm experiencing in our desire as Christian folks, as people of faith, to the right to want to build families, to be grandmothers and grandfathers, to be parents, to be mothers, to be loving fathers, to want to be able to see ourselves have the families that we desire, to experience the pain of loss of process, of being in that process, and to extend the love of Jesus, to be able to see ourselves replicated in that family making process, in that family building process. And this bill is dangerous to that. This bill and the opportunity for discrimination, the opportunity to be harmful to Georgians of all races and creeds, of any phobia. I am a person who was raised in a little town called Gray, Georgia. I don't know if anybody might know where that is. You know where Gray, Georgia is. Yes, that's why we love you. That's why you got the shout out while you outside of the room. So in places like Gray, Georgia, Bradley, Georgia, Twiggs County, where my daddy is from, you don't have a lot of access. You kind of have the practitioners that you have. And bills like this, if people turn you away, they just turn you away. If they don't understand, or they don't believe, or they don't accept, or they have fear about what it means as it relates to their faith or their beliefs around their practices. And I think expansiveness around that also matters, right? I'm a seminary graduate from Emory University, also here in the state of Georgia. And so I think that expansiveness, there needs to be room for it, but it is bills like this that actually restrict the expansiveness to engage your faith. And the engagement of faith is necessary. It's the bill that keeps you from being able to be in that process of the wrestling of your faith, which I think Jesus also invites us to do. To be able to go into the wilderness and take that time to have the 40 days to sit with the Father and be able to ask the questions and pray and fast and do the things that bring you to the place of clarity, right? And I think we have the space to be in process with each other, and I think dangerous bills like this keep us from being able to do that. So if we can be people of faith together and be in communities of faith together, I think we can trust that our belief in the love of family, the love of God, the love of community would cause us to vote no and not move this bill forward, and I invite us to do that today. Thank you.
Any questions for Reverend Dillard? And Jones County High School, that's the Greyhounds, right?
Yes, it
Yeah,
is.
from Gray. Yep.
Come on, class of 2003. Shout out.
All right. Looks like Peter Corman. Thank you.
Well, I wrote notes for the sake of brevity, because there are people in this room who know that I can speak for a long time. I want to say, well, good afternoon, acting chair and members of this committee. My name is Peter Corman. I'm a Jewish citizen of Fulton County, Georgia, for over 40 years. I'm one Jewish citizen. I'm a Jewish citizen who is extraordinarily grateful and was to this committee and the members that were here 2 years ago, including Representative Panich, when we passed HB 30 and got the overwhelming support from the General Assembly and in that passing that. So today I am here as a Jew, which is important to note. We have about 140,000 Jews in Georgia out of a population of approximately 11.4 million. But Jews do not represent the community as much as we represent a population. And do we experience discrimination? You've seen that vividly since October 7th on our streets and our campuses. That said, this discrimination has not come from governmental bodies, from public bodies. It has come from private organizations and citizens, which is why I believe I'm here to support RFRA. Why we're going to have bigotry from private citizens and organizations, that is most certain. That is a condition of human nature. The concern is when we get discrimination from public bodies, which I think is being conflated from the testimony that I've heard. I'm here in support of Senate Bill 36, which is now under consideration in your committee. My hope is that you will move finally, after 10 years, this legislation forward. I hope it's not significantly modified, as the governor has promised. If it reflects the federal legislation, he will sign it, and we will have a governor who will sign RFRA this time. As I said, Georgia's Jewish population is approximately 144,000, or about 1% of our state population. We are batting way above our average in this room today, so thank you for that. Our representation of elected officials throughout the state of Georgia, and I'm not just talking the state government, I'm talking local governments, school districts, other governmental bodies, is much smaller than 1%. So why would RFRA be important for Jews or other religious minorities? Well, for someone who is facing public discrimination from a governmental body, especially smaller groups, the burden to get exceptions and fight that discrimination is much higher. We don't have support from a large majority population as being 1%. The RFRA Act, right, Religious Freedom Restoration Act, is vital for our religious minorities. It doesn't hurt religious minorities, it's vital for religious minorities such as our observant Jewish community. Significant movements, and this is not in Georgia, but particularly in California, in local municipalities, in New York City, where I am a native, but thank you for accepting me 45 years ago, 50 years ago to Georgia. In Michigan, where local organizations have become involved in local governments and they have advocated positions, and I won't speak too graphically, but they have advocated positions and public doctrine and law, which would actually ban certain aspects and vital aspects for Jews to practice their religion. So let's start with, and I believe Representative Panich mentioned the kosher laws. There have been activists in local municipalities elsewhere. We're fortunate to live in Georgia. We're fortunate now to live in Georgia. Things may change in 10 years, which is why we need to do this before the fire occurs. Which would have advocated positions which would have interfered with our laws of kashrut or kosher and the way we deal with food. other laws which have touched in California and New York, and actually touched in Georgia. I saw it here at our Super Bowl, where we had groups advocating against circumcision. I don't want to be too graphic about that. Some saw it as, the equivalent of genital mutilation for Jews, for male Jews. This is prescribed in our Torah. It's important. We don't want to see a public body. I don't mind, I do mind, but I can deal with private organizations and people not liking the way we conduct our faith or our lives. It is when a public body interferes that it becomes especially egregious. And I believe RFRA provides, this language provides, it says to that public body, what is your compelling interest for interfering with the practice of that religion? And it provides a balance for that, which is why I believe it's important. In states, this has been brought up in New York officially by the education superintendent, where they provided a curricula which would have interfered with Jewish day schools. And we have Jewish day schools here. It would have provided a very rigorous requirements that the small parochial schools would have trouble meeting because they were also teaching religious principle. And ultimately, a Democratic governor in New York State threw out that effort and overrode that effort by the state superintendent. In the interest of respecting time, and I'd be happy to provide specific sources on all of this, and really some of the challenges that Jewish organizations and people have faced and face elsewhere, and the risks. There are risks here in Georgia right now. I'm asking this committee to please move to support the protections of RFRA for incorporation into Georgia law as written in Senate Bill 36. Thank you very much for your time today.
Thank you, Mr. Corman. Any questions for Mr. Corman? All right, thank you.
Thank you.
All right, Stacy Fox. Stacy Fox. Going once, going
She's no longer here, Mr. Chair.
Okay, thank you. Reverend Andy Woodward.
She's not here either.
Okay. All right. Bentley Hudgens, you signed up twice. So,
Oh, my bad. I'm sorry.
You signed up twice.
I was really excited.
All right.
I really wanted to talk to you. Good afternoon, everybody. My name is Bentley Hudgens. I'm the Georgia State Director of the Human Rights Campaign. I'm very excited to be with you all today. Thank you so much for allowing us the opportunity to testify. A lot of what I wanted to say has already been covered by my incredible friends, so I will keep it brief. So I just wanted to illuminate some more of the instances in which RFRA has been used or abused. When the Federal Religious Freedom Restoration Act became law in 1993, it was designed to protect minority religious groups' constitutional right to freely exercise their religious beliefs. Since RFRA was seen as an important safeguard for our country's most vulnerable groups, it was supported by a richly diverse coalition of religious and civil rights groups. However, despite the focused, straightforward intent to protect minority religious groups, individuals and businesses have sought to use RFRA as a license to discriminate and impose religious beliefs onto others. Police officers across the country have used state RFRAs as an excuse to refuse orders they claimed offended their personal religious views, including a police officer who asserted a religious objection to his community policing duties at a mosque, claiming a moral dilemma, and an officer who cited religious liberty in his refusal to police a gay pride parade. A pastor who helped kidnap a child in Virginia from her legal guardian cited the federal RFRA as his legal defense. In New Mexico, a local religious leader cited the state RFRA when he appealed a conviction for sexually abusing 2 teenagers. A federal judge just held that, let me just make sure I say this right. A federal judge just held that the federal RFRA prevented a full investigation of possible child labor law violations because the individual under investigation said that his religious beliefs forbade him from discussing those matters with the government. Another federal judge held that the federal RFRA permitted a for-profit business to fire a woman because the owner disapproved of her being transgender. Recently, for-profit businesses in Texas cited the RFRA to decline to provide health care coverage for PrEP, a key medication in the fight for an HIV-free generation. These unintended consequences of the federal and state RFRAs have undermined our core civil rights protections and jeopardized the health and safety of vulnerable people. Business leaders and many faith leaders like those here today have opposed efforts to enact these laws across the country, knowing the harm they can cause. Like my colleague at the ACLU said earlier, in 2015, Indiana's disastrous attempt to pass RFRA actually resulted in the loss of 12 conventions and had a negative economic impact of up to $60 million. This legislation is substantially similar to a bill vetoed by Republican Governor Jan Brewer of Arizona, Senate Bill 1026, in that it allows businesses to be sued for enforcing civil rights and health and safety laws and regulations. Here in Georgia in 2016, Nathan Deal, our then governor, vetoed a RFRA stating that Georgia is a welcoming state. It is full of loving, kind, and generous people. I intend to do my part to keep it that way. We believe, and I believe, that Georgia is still full of loving, kind, and generous people. It is crucial that Georgia remain a welcoming state for all people who call it home. I grew up in Henry County, an unincorporated Henry County. My mom is a retired public school teacher. I went to school in Macon and got my degree from Mercer. I now live in unincorporated DeKalb County. I love being in Georgia. I don't want to leave. As an Asian American and a queer person, I understand what it looks like when discrimination goes awry. And I love being here. And I know it's my job to come here, but this is also a personal thing for me. I just got engaged to my wonderful partner, Robert Bradford, and when I'm thinking about starting a family and I'm thinking about what my future looks like, I don't want discrimination to be a part of that. And I know that y'all don't want discrimination to be a part of this as well. And without non-discrimination ordinance at the state level, and with most of the state not being covered by a non-discrimination ordinance at the local level, this is just a really ripe opportunity for people's futures to be meddled with. Thank you.
Any questions? No questions. Thanks for testifying.
And I'll email this for you all as well.
Absolutely. Absolutely. Anybody's welcome to follow up with written submissions by email to the committee. House Judiciary list and emails are online. First name dot last name at house.ga.gov. Francisco Vega. And while Mr. Vega is coming up, I think the civil rights movement's been invoked by both sides, and right out the window of the House Judiciary Committee we got a statue of Dr. Martin Luther King. Had some students from Gwinnett County want to see that the other day. All right, Mr. Vega.
Thank you, Mr. Chairman. And thank you to this committee. My name is Pastor Francisco Vega, and I oversee Ark City Church in Cobb County, Georgia, as well as a multiplicity of multi-ethnic and multi-generational pastors, over 60,000 congregants of faith, who unequivocally stand and support a strong yes to pass Senate Bill 36. Just a quick fact, over 47% of Americans claim faith, which means close to 50%, which would be upwards to 175 million people ascribe to faith in the United States of America. During COVID, due to strict rational basis, we saw bias too often by non-believing bureaucrats bleed out, which affected the minority and the black churches and all churches alike. Over 70,000 churches have been estimated to have permanently shut their doors forever during COVID. Government has a litany of examples where it can potentially fall on the wrong side of history initially until in all fairness, different statements I've heard today were people of faith, and for me, mainly Christians voiced fairness and freedom. From chattel slavery to Dred Scott to Jim Crow and more, it was people of faith, mainly Christians, who fought for freedoms that didn't merely benefit Christians, but all Americans alike. We cannot rely merely on government to biasly interpret the necessity of faith of others, but to respect it as the First Amendment intends with any loopholes. Many civil rights and liberties, even as recent as the First Step Act, all the way to the Civil Rights Movement, I would remind respectfully, were pastors and ministers and rabbis and who opened freedoms that did not have a stringent and ardent history of seeking to remove liberties or discrimination. For the sake of total transparency and honesty, we've seen equal attempts to discriminate against Christians, with a host of Supreme Court cases, from prayer in school, praying in athletic events, to often simply due to feeling the Bible supports traditional views of sexuality or marriage and gender. And to me, this reveals a sentiment of extreme prejudice against Christianity. This is the same Christianity that has given us biblical influence, contributing to the greatest constitution in the history of the world, allowing us to become the youngest superpower nation in 248 years of our existence. I'm asking that we join courageously with 39 states and FRA laws in almost all 50 states to simply respect the religious rights of all people of faith, to disallow real religious discrimination simply for believing the same Bible that influenced the freedoms of our great nation. Thank you for your time. That's all I have.
Thanks a lot for coming. Any questions? All right. Thank you. Brooke Mells. Brooke Mells. Okay. All right. It looks like we don't have any more opponents signed up. So is anybody here who intended to speak who's in opposition to the bill? Yes, sir.
Hello, Mr. Chairman, members of the committee. My name is Michael Schulte. I'm a pastor. I'm a Lutheran pastor here in Atlanta, Georgia. And I really want to focus in on the stories of people who are scared in our state that laws like RFRA will prevent them from being able to access health care, be able to adopt, be able to go to all businesses and receive services. And I think, too, I am a product of the Lutheran school system. The Lutheran school system is the second largest parochial school system outside of the Catholic Church. I went to Lutheran school K-12. I have never felt, as someone in the United States, that my religious freedom or my religious liberty was limited. And I'm pretty damn proud to be an American because I'm able to exercise my freedom of religion even when my evangelical colleagues and whatnot disagree with me. And so I am concerned about people who want to access PrEP, people who want to go to doctors that allow them to get gender-affirming care, people who want to be able to, again, prevent HIV. Georgia has one of the largest transmission rates of HIV in the entire country. Why would we pass a bill that would empower more people to get HIV? I'm also concerned about same-gender loving couples who want to adopt children and might be denied by the state in doing so. This has happened when RFRA laws were passed in South Carolina in 2019. Luckily, that decision was reversed in 2021. I'm very concerned that if I wear a pin like this that says that LGBTQ people are safe with me and I walk into certain businesses, they might decide that they do not have to serve me because we do not agree ideologically. That is a huge concern for me, and it's a huge concern for the people of my congregation, 40% of whom identify as LGBTQ. And I think, as the Senator Setzler says, we want to have a balanced bill. We want to have a middle-of-the-road bill. We want to have a neutral bill. Well, let's do that, because there hasn't been a single person who stood up here today and said, hey, I'm against religious liberty. And there hasn't been a single person who stood up here today and said, hey, I'm against religious freedom. So we need, the absence of language is ambiguous. And Senator Setzler says, no, it's not, that this bill is purposely unambiguous. No, the absence of language is ambiguous. It's ambiguous as to whether local control, local ordinances like ordinances in Atlanta or Gwinnett County, would they still be in effect, the non-discrimination ordinances, or not. That is ambiguous. So let's add language to the law that says that we have local control. I'm a child of the conservative movement. I have uncles who are Republican representatives in the state of Illinois, a really great place to be a Republican. And they all, right, all of these people, I grew up on the values of local control. So why would we pass a bill at the state level that wouldn't let Atlanta or Gwinnett County or these places to have non-discrimination ordinances? Let's make that clear in the law. Second is that I do not understand why we would not want to add a civil rights clause to a bill like this. Why would we not want to make it balanced? What we're hearing from is not people against religious liberty. What we're hearing from is people who just want to be protected by the state of Georgia. People who are trans, people who are queer. We want to be protected by the state of Georgia, and we're asking you to add that language to the bill to make sure that it is balanced, to make sure that it is middle of the road, to make sure that it is neutral, as Senator Setzler claims. And so that is the context of which I'm coming to speak today, because I'm concerned as a pastor for my people and their ability to pursue happiness, to live a good life in our state, because they are the people, queer and trans people, they are the people who will be discriminated against if this bill is passed. And that is so unfair and it's so unjust, and to me it is not Christ-like. And I hope that we can all agree that we're for religious freedom and we also are for non-discrimination in our state.
Thank you. Any questions? No questions. Thanks for your testimony.
Good afternoon, Mr. Chairman and members of the committee. Good afternoon. I'll try and be brief because a lot's already been covered. I really would like to focus on just some practical matters. So first, I'm an attorney. I run a small private law firm that does mostly personal injury cases. I also serve on the religious liberty section of the Georgia Bar. I'm a major in the Georgia Army National Guard, where I'm a judge advocate, and I wear a couple other hats. But I just want to be clear at the outset that I am not speaking in any of those capacities, none of those capacities. I'm just speaking as an individual, as a lawyer who litigates cases, and I just want to talk about some practical things. So the first thing that I wanted to flag is sometimes when this bill comes up, there's a concern about economic impact on Georgia. And I'd like to argue that that's not really a legitimate concern, because when we look at the top states in the country to do business, it is states like Arizona, Texas, Florida. All those states have RFRAs. This puts us on the same footing as those states. This is not going to make Georgia less competitive. The next thing I wanted to talk about is this concern for whether this will facilitate discrimination. Obviously, discrimination is a very bad thing that we want to stop and prevent. But I want to be clear that what this bill doesn't change the landscape. A Religious Freedom Restoration Act only prevents government action. And so it's not as if people will be able to do bad things after RFRA that they couldn't do now. That situation doesn't change. All RFRA does is stop the government from taking action against religions, including especially religious minorities. And I wanted to speak a little bit more about how this bill should be passed in its current form. There's a few reasons for that. One is it puts us kind of in parity with the way the law currently is in the federal landscape. All the federal non-discrimination laws like Title VII, Title IX, those still apply in Georgia and will continue to apply in Georgia the same way they apply nationwide. There's a lot of value to adopting the exact federal version of RFRA because, frankly, we have 30 years of case law that already discusses how these laws interact with federal non-discrimination statutes that, again, still apply in Georgia. That's incredibly important for a litigant, especially a Georgia litigant. Because when you pass unique or nuanced or different laws, it complicates things. It creates uncertainty in litigation. It raises the expense of litigation. And this assembly has recognized that before. The Georgia Civil Practice Act that we passed back in the 1960s is essentially a codification of the federal rules of civil procedure. And the portions of that statute that have received the most challenges and the most litigation are the ones that we have departed from the federal rule, because there is no large body of case law that we can draw upon, so there is no certainty for litigants or putative litigants, and they're left to reinvent the law at the Court of Appeals. This just simply did the same thing in 2012 with the federal rules of evidence, adopting the federal rules. And again, the most litigation that we get were those provisions that departed from the federal rules. So I think it's incredibly important for this litigation to adopt the federal version because it provides the most certainty for parties, potential litigants, and litigants. Same with regard to anti-litem requirements. I know there's been some discussion of whether this bill should be amended to include an anti-litem requirement. Respectfully, I think that that's a bad idea. already, under Georgia law, if you bring a claim under 1983 for a violation of a federal constitutional right, for example, Fourth Amendment, or unlawful seizure, there's no requirement for an anti-litem notice. So if there was an anti-litem notice requirement for the RFRA, it would essentially be putting First Amendment claims in a second tier beneath Fourth Amendment claims that you can bring under 1983. There's another reason that an anti-litem requirement doesn't make sense for a RFRA. Anti-litem requirements for claims against state and local governments are often important because there is a discrete act in the past tied to a statute of limitations. The vast majority of the claims that are actionable under a RFRA are continuing violations. And so it's hard to set a time. Because if the claim is, oh, I should be able to grow a beard or have long hair when I'm going through my 9th grade class, that violation is ongoing forever. There's no discrete time that it happened. So anti-litem notices would be complicated. They'd be different from current anti-litem notices. They'd create a ton of unnecessary litigation, and they would relegate the First Amendment interest protected in RFRA to something lower than for the Fourth Amendment interest that you pursue under 1983. The last thing that I wanted to talk about is Representative Evans' comment about specific instances in Georgia. And I do not have instances where someone lost because Georgia didn't have a RFRA. I'm not going to overpromise there. But what I will do is I'll speak to this practically as a lawyer who takes cases. When I screen potential cases that get called, I will go down a checklist and say, is this action viable in Georgia? And if I think it's not viable in Georgia, it's not that I take the claim and then lose it. It's that I don't take the claim in the first place. So I think a lot of the violations that are happening of people's religious beliefs are because claims are being declined. And I want to be clear that these claims are almost all claims by minority religionists. So in my experience, vast majority of my cases are tort injury cases, but I've taken an occasional pro bono case, and it's been a situation such as a Muslim prisoner who wanted to grow a beard. Fortunately, we were able to make some headway on getting him that beard because of RLUIPA, because of the Religious Land Use and Institutionalized Persons Act. That applies in Georgia. So we were able to work on that and win some right for the Muslim individual to wear a beard. If that had been a Muslim child at a K through 12 school, we wouldn't have won because RLUIPA wouldn't apply there and RFRA would. And so I've talked to my friends who do religious liberty litigation because I don't do a lot of it. And the fact that Georgia doesn't have a RFRA is a fact on their checklist where they say, ooh, well, in that case, that's not a claim that we're going to pursue. And it's been a similar situation. I also serve in a military capacity. And these are also claims in Georgia where a soldier, either a Sikh soldier or Mormon soldier, we have one case where it's a Rastafarian soldier, will want an exemption to the grooming requirements, either to have dreadlocks or to have a beard. Not all those exemptions come out the same way. Sometimes they're in a chemical unit where they have to wear a gas mask, and so the compelling state interest governs. Other times they come out favorably. But again, the only reason those Georgia citizens are getting protection for their religion is because of the federal law that applies to the military, not because of the state law. And so literally, prisoners are getting more religious liberty protections than K through 12 students are, and this RFRA would fix that, and adopting the exact federal version would be the best way to do it that would minimize the cost of litigation and provide the most certainty to putative litigants.
Thank you so much. We do have a question, but let me just say RLUIPA got signed by President Clinton also, right?
I believe that's
all right,
correct.
so everybody tell him he got two shout-outs in the House Judiciary Committee. And then I got to tell you, I couldn't help my mind wandered to Senate Bill 68 when you started talking about case triage in Georgia under legal standards. So I know that's your other practice area, but I think what you said there was revealing about, case selection for people out there coming in there with legal matters lawyers. So I know you came here to talk about RFRA, but I think you shed some light on some other issues today. So with that, Representative Evans.
Thank you, Mr. Chairman. Thank you so much for being here. I obviously have great respect for you as a litigant because we've shared cases before and do now. And I'm asking this, I have two questions. The first question is I'm really trying to work through in my mind because I know about the Constitution. I do First Amendment work. And I'm having a hard time understanding if the problem is, as you've also stated, it's going to be the state. This is about state action. Mm-hmm. I'm having a hard time envisioning a scenario where the state could do something that infringes on religion that wouldn't give rise to a claim under the First Amendment of the federal Constitution. And that, as I've been sitting here trying to read cases, the case that we were told about, the Augusta case, that plaintiff moved under federal law. That's why she was in federal court. She moved under the First and the 14th Amendment. So what scenario can you think of where the state would be infringing on religion such that you would want to bring a claim and you wouldn't be able to use the First Amendment?
So I think the answer to that question is anywhere where there's not a federal angle. So I'm sorry, my phone's buzzing. I'm trying to silence it so I can pay attention. So obviously there's the RLUIPA angle. There's Title VII, Title IX anti-discrimination provisions that apply that are federal laws. Where it's going to apply really is state, local, and county governments. And it could be in the education setting. For example, if there's a K through 12 student who wanted a halal or a kosher meal or wanted a break during a certain period because they have to pray or needed to fast for a certain period, those are where they're going to arise, because they're in K through 12 education. There's not those federal protections, right? In college education, there's a tremendous amount of federal money that comes with strings, but the state has reserved a lot more authority in K through 12 education. So those kind of cases are the ones that are likely to arise. And then there can also be cases just in regulatory agencies where it could potentially arise. But the core ones is going to be the core cases that we're talking about are, I would like this haircut or not that haircut or this meal or this break for a prayer time, or you guys are taking Easter off, but I don't celebrate Easter. Can I take another day off? Those are claims that currently wouldn't be covered federally that the RFRA would protect.
But wouldn't it be? I mean, if the state, let's play a hypothetical here. If a student wanted to do something in a K through 12 school, have a kosher meal or whatever, and the school expelled the student for that's going to fall under the First Amendment. I mean, that student, just because they're in the state of Georgia, just because they're in a K through 12 school, they're still a citizen of the United States of America, and they still have protections under the First Amendment. So that, to me, I don't see how that student doesn't have access to First Amendment protections under the federal Constitution.
Well, when it comes to the free exercise provision of the First Amendment, the federal rule that apply would be the Employment Division versus Smith case from 1990 that says if it's a general rule of applicability that there is no constitutional violation. Obviously, after 1990, RFRA passed, got rid of the neutral law of general applicability standard and made it what the previous standard under Wisconsin versus Yoder, which is if it substantially burdens religion, the state has to have a compelling state interest advanced by the least restrictive means. And so under that situation, the First Amendment protection would only provide the Employment Division versus Smith protection. It wouldn't provide the RFRA level protection that currently exists at the federal standard because of the federal RFRA. And so in that case, if the rule was a neutral law of general applicability, which is to say we only serve this lunch to everyone, nobody gets any exceptions, then that individual would lose under the federal First Amendment standard that applied because the federal RFRA does not apply, but would win under a Georgia RFRA.
But we could probably play out that where if you have an exception, but let me ask you the second question, and I appreciate that because I'm trying to figure out where the potential hole may be. But can you give me, and I wouldn't want you to reveal any clients, but can you give me a fact pattern of someone that has come to your office for one of these cases that you've turned down because of us not having state RFRA?
I cannot because we do not advertise for those cases. I've only taken a couple in my career pro bono.
Are you aware of any scenario that has walked into one of your friends or colleagues' office that they've told you they didn't take because of Georgia not having a state RFRA?
I have talked to people that take religious liberty cases, and they did not have specific examples, and I cannot provide that to you now. But I will say what I said before, which is that they do screen for lack of a state RFRA. And if there is a case that would depend on prevailing under the RFRA standard versus the Employment Division versus Smith standard, they will decline it. But I do not have names for you.
Okay, thank you.
Any other questions? All right, thanks so much for coming and testifying. And, it seems like anytime anybody says anti-litem notice around here, GMA shows up. So Ryan Bauer Sox.
He's got a chip in him.
Well, you might have blown my surprise a little bit, Mr. Chairman. Thank you, Mr. Chairman. Members of the committee, Ryan Bowersox with the Georgia Municipal Association. As you might have mentioned, I am here on a little more of a different angle, specifically representing 537 cities across the state. Over approximately the last 10 years, GMA has been heavily involved in plenty of conversations regarding RFRA legislation, and we have always understood the purpose behind legislation like Senate Bill 36 to ensure that religious discrimination does not occur, burdens on the free exercise of religion do not occur, and if there is a burden or discrimination, that a remedy is provided for that. We do not believe that cities are out there intentionally discriminating against individuals based on religion. We would, of course, never support that. We would never sanction any such discrimination along these lines, especially anything intentional. Our fear regarding some of this legislation is that this may inadvertently occur at times. With RFRA legislation introduced in the past, GMA has consistently advocated for an anti-litem notice, a required notice, and then a period to cure in case there is an inadvertent burden upon religion. Our hope is that no city would be doing this intentionally, and that if this was brought to their attention, the quickest remedy for the plaintiff in that scenario would be notifying the city of this inadvertent burden and allowing them the opportunity to cure. Our concern is that city officials are very familiar with the main religious practice out there, but there are many more besides these major faiths. For example, the U.S. Department of Defense recognizes 221 different religions. Cities in Georgia are just simply not prepared with every decision that they make to evaluate how that may impact 221 different religions. Many policy and procedures a local government could adopt could inadvertently have this burden upon the practice of religion. So what we request, as we have in the past, is a required notice to the local government, to any government entity, and the ability for the opportunity for them to cure within a very short, definite period. This would allow any member of a religious group that feels there is a discriminatory practice to notify the local government, articulate the burden, articulate the practice, the ordinance would have it, and give them a chance to address this before taking them to court, incurring costs, and incurring more time to potentially get them a remedy in this situation. We view this not only as a way to protect the government entities, but also in line with the intent of the legislation, is quickly and cost efficiently providing a remedy to the aggrieved individual. If the city addresses this in a reasonable time, either amending or repealing the practice, then the issue would be moot at that point. Relief would be provided to the plaintiff. If the city fails to address it, or if they believe, as Senator Sessler said, they look at that balancing test and believe they have accomplished that balancing test, if they disagree, then the aggrieved party still has the opportunity to seek redress in court. So with that, we appreciate the opportunity to comment on this bill. We urge you to consider an amendment to this to provide that notification requirement, the opportunity to cure, and I'm happy to take any questions at this time.
And Representative Holcomb has a question in a minute, but I've got one for you. So the bill that has been discussed several times that the House and Senate passed years ago that Governor Deal vetoed. By the way, he's written a great book, Veto the Cat, and these stray cats came to live at the governor's mansion, and he named them Veto and Bill. That's where that came from. But it had an anti-litem notice requirement. So, right?
Yes, sir. House Bill 757 in 2016, I think it's in lines 198 through 220, had the anti-litem requirement in there.
And you've got 537 cities in Georgia.
Yes, sir.
In addition to all the counties that we've got.
In addition to the counties and all the other government entities that would be included in this bill.
And you're here representing the cities, and you're concerned about the bill without the anti-litem notice requirement. You're asking for an amendment, and that's it.
Precisely. Yes,
Thank
sir.
you. All right.
Thank you, Mr. Chairman. In terms of the definite period, if there were an amendment proposed, what would be your suggestion on that?
What we have proposed, because we recognize the burden on religion would be an intense one. It would be an intense one, and you want to seek relief as quickly as possible. We asked for a 30-day notice with a 15-day cure period. Very tight. If we are notified of something that is infringing on someone's practice of religion, the quickest thing would be to try to pull it off the books or repeal the practice at that point.
Okay. My second question is, the version that we have is the version that was passed by the Senate.
Sure.
And I don't see a carve out for existing non-discrimination ordinances. Do you?
No, sir, I do not read that in the bill.
Okay. All right. Thank you.
And did you put pen to paper and draft up an amendment?
Yes, sir, I did.
Okay. I will circulate that to the author and the committee shortly.
Perfect.
Any questions for Mr. Bauer's office? All right.
Thank you.
Okay, next witness, Aaron Birch.
Good afternoon to the members of the Judiciary Committee. Thank you for hearing me today. My name is Aaron Birch. I am a Cobb County Georgian since 2018 and a member of the Church of Jesus Christ of Latter-day Saints. Chairman Smith earlier referred to us as Mormons, a religious minority in this state. I come before you in strong support of Religious Freedom Restoration Act Senate Bill 36, a bill that protects our fundamental right to live our faith, a right that I've seen trampled elsewhere. I moved here from Colorado, escaping policies that targeted people of faith. We watched for many years as the state there harassed Christian baker Jack Phillips with fines and lawsuits for decades for exercising his beliefs. As a Latter-day Saint, I relate to a similar history too well. In 1838, Missouri's government issued an extermination order against my ancestors, driving them out of their homes with violence and imprisonment. The church members at the time appealed several times to the federal government, but were told there were no protections that could be offered to them. Even their neighbors of other faiths feared to stand up and speak on their behalf because there was no protection from retaliation. I left Colorado to avoid the growing shadow of similar persecution, and Georgia has been a refuge. For 7 years, I've thrived here, raising my family and cherishing this state's kindness. The Religious Freedom Restoration Act isn't just about protection, it's about building a lasting community of faith in the public square. Laws like this empower believers of all stripes to stand together, speaking up for one another's freedoms. When my Baptist neighbor defends my right to worship, or I champion a Muslim's right to practice, we weave a stronger Georgia. This bill ensures that diversity, my diversity as a Latter-day Saint and a Western transplant, flourishes, not fades. It prevents government overreach from silencing us, fostering a culture where we lift each other up. Colorado showed me that without laws like the Religious Freedom Restoration Act, faith becomes a target. Here I've found peace. Please keep it that way. Vote yes on Senate Bill 36 to secure Georgia as a beacon of liberty and a community where all faiths thrive. Thank you.
Thank you. Any questions? All right. Thank you. I don't have any more people signed up in opposition. If anybody is in opposition, please let me know. We're trying to keep this testimony pro and con. So I'm out of cons at this point. So next witness in that case is O'Shea Vega.
O'Shea.
O'Shea. Good afternoon, Ms. Vega.
Hi. I'm so honored to be here. Again, my name is O'Shea Vega, and I am here as a Christian, a minister of the gospel, a wife, a mother, a community leader. I'm also a proud graduate of Spelman College. I served the Atlanta public school system for over a decade, and I am here in support of this bill. Although separation of church and state is often taken out of context, many of us know the true context. Our founding fathers wrote and often discussed the importance of ensuring that the government did not have overreach in our free exercise of religion. Their original concern was not because of a past precedent in the new government, but based on the potential of the overreach of government control as seen throughout the history of mankind. The equality of women's rights is not based on if we have or have not been discriminated against, but simply on the equality of the human standards and just humanity in general. The equality of racial equity is not founded or based on if someone has racially discriminated against me, but solely based on my inalienable rights as a United States citizen. Ultimately, our First Amendment rights, including religion, should show equality in the standard of strict scrutiny as speech, press, and assembly. I do not think it was by happenstance that the First Amendment was even claused in the specific order. Congress shall make no law respecting an establishment of a religion, prohibiting the free exercise thereof. And then it goes on to speak about press, speech, and the rights of us to peaceably assemble and to be able to petition the government for redress of grievances, which we are all benefiting from today. Although there are many things that people can identify me with. My Christian faith is who I am and defines how I live. This bill protects people of faith like me to ensure our full equality and our First Amendment rights. I also think it's important, and I know there were a lot of different cases presented, but I just think, just for the record, and just to be specific, there were certain cases presented about potential landlords discriminating, which we know that the Fair Housing Act prohibits discrimination on various bases, including sexual orientation and gender identity. And also there was a reference about a father and attempted child abuse seeking to use RFRA. And if it was specifically the one in Indiana, the Indiana Court of Appeals actually struck it down and did not only allow not the abuse of children, but also did not allow him to abuse RFRA. So again, I think it's important for us to be able to, as she was stating, just kind of show that RFRA was not allowed to be abused in those specific cases. And ultimately, I'm just here because I believe this bill should be supported, again, for our full equality of standards and our First Amendment rights. And I ask you to pass this bill. Thank you.
Thanks a lot. Michael Schulte, did I ask for Michael Schulte earlier? Okay, well, we got that covered. Okay, thank you. All right. Thank you. Any questions for Ms. Vega? Thanks for your testimony. All right, next witness, John Citizen.
Okay. Thank you, Mr. Chairman.
Thank you.
Senator, appreciate you having me, all your people here today.
Thank you.
I am Bishop E. John Citizen. Edward is my legal name. I am a bishop of a church, Pentecostal church, and I'm here because I support SB 36, simply because I'm seeking the same rights as the LGBTQ community wants. I love everybody. I don't disrespect nobody. I got friends who are gay, but it's not about gay people. This bill is not about gay people or we hate or don't like people. We love everybody. I love everybody. But I want the same protections that this group of people are fighting me for. Again, if you want protections, you can have it. But I want the same protection, and SB 36 gives me that same protection. I'm not Jewish, I'm Cajun. And being Cajun, I don't have an issue with Jewish people. I don't have an issue with African people. I don't have an issue with gay people or lesbian people. What I have an issue with, when you tell me I got to go along with what you want. I want to be a Christian, and I want to be left to do my worship my way, the way God intended me to do it. My Bible says what it says. If you don't agree with it, don't read it. If you don't like it, don't practice it. I'm not going to push my agenda onto you, but don't push your agenda onto me. And SB 36 gives me the fair balance with the government, where the government can't come tell me and my church that I can't hire, or who I can hire, who I can allow, who I can't allow. I just want the same protections all these other groups want for their rights. And as a Christian, I want that same protection. And SB 36 gives me that protection. That's my statement.
Thank you. Any questions from the committee? All right, so I see you're from Douglas County, and you said you're Cajun.
Yes, sir.
Where I'm from, you got two places with crawfish etouffee. Where do you like that in Atlanta? We've been here a long time, so just a brief food.
My gumbo is the best gumbo you ever gonna eat.
All right.
My sauce piquant is a good red gravy. It's a good sauce piquant. But I'm telling you, I love America. I love my country, and I love Georgia. But what I don't want to do is fight with other groups for my rights. I deserve the same rights as other groups desire. I want the same rights for me.
Thanks so much.
Thank you.
Harvey Persons.
Thank you, Mr. Chairman, and good afternoon to you and your esteemed colleagues. And first of all, I'd like to thank you for your service to the people of the great state of Georgia. What you do is an awesome responsibility that I know takes up a great bit of your time, energies, and efforts away from your family. And we appreciate that more than I can tell you. And I'm very honored to be here today. And thank you for taking the time to listen to us. My name is Harvey Persons, and I want to thank you for your time to hear the discussion, and there's been a lot of it today, on Senate Bill 36, better known as Rifle Bill. And I'm here to speak in support of that bill. So you ask yourself maybe what gives me reason to, or the ability to even speak on a piece of legislation as it relates to governments, both local and state, imposing overreach on individuals and the citizens of our great state. I'm speaking as a former mayor of the city of Douglasville, where Douglas County is, and it's the county seat. It just so happens to be the 25th largest city of the 537 that the GMA individual spoke of earlier. I was the former mayor. I spent a little over 9.5 years as a city council member. I served as the vice chair of the county's planning and zoning board for many years. I also served as the chair of the city's planning and zoning board for many years. I served on the Atlanta Regional Commission, on several of their committees. I also served on GMA's executive board and several of their legislative committees that lobby individuals like yourself to pass certain legislation. And I also served on something called MAMA, which was the Metropolitan Atlanta Mayors Association. Now, all that being said, I'm not here to speak about me, but I am here to speak about that I have many years of experience, both either as an elected or an appointed representative of local, state, and county government. I've seen the opportunities, not saying that it has, I have seen the opportunities for local, state, and county governments to legislate and overreach and have the ability to restrict our individual freedoms. I'm not here to restrict or ask you to pass any bill that restricts anybody's religious freedoms. I'm here to speak as a member of the faith community and a desire to see you pass this bill in its current form that mirrors the federal legislation, which has stood litigation and has passed the Supreme Court test. But then when it did in 1997, it exempted local and state government. And I'm here to ask you today to pass this bill in its current form. And you may ask yourself, well, what are state and local governments going to do to pass laws to restrict our religious freedom? And what case law is already out there? It's hard for us to determine the future of legislation or ordinances that may come up to be passed. And what I'm asking you to do is, as the gentleman said a little earlier, let's put a sprinkler in to prohibit maybe a firestorm that may happen in the future. I carry homeowners insurance. I carry automobiles insurance. It's not because I've had a wreck. It's to protect me in case I have a wreck. And that's what I look at this bill, RAFA, Senate Bill 36, is doing. Whether there's case law out there or not, let's put something in place that'll be a protection against future overreach by local, county, or state governmental agencies. So with that being said, I want to thank my good Senator Setzler, for bringing this bill forward. I believe this may be fourth year in a row. Thank him for that. Thank you for your patience and your indulgence this late in the afternoon to continue hearing. But I would ask humbly that you pass this bill or recommend passage of it in its current form, which is measured, balanced, and fair, and it protects the religious freedoms of the people of this great state that you, I'm sure, humbly represent. Thank you for your time, and hope y'all have a blessed afternoon. I'll open
Thank you,
for any
Mr.
questions.
Mayor. We have a question from Representative Holcomb.
Do you consider the cities that have enacted non-discrimination ordinances to have engaged in overreach?
Well, I wouldn't say that or answer that based on not knowing what they have actually enacted. What I'm saying is the potential for future actions that could be overreach. So respectfully, I understand your question, but I don't know what cities have enacted without looking at each individual ordinance to see what they've done. What I'm here to talk about or ask for is that future protection, because none of us know what can happen in the future. None of us know who's going to be sitting here to represent us in the future or what they may decide to do. So let's put that sprinkler or that protection in place to prohibit that so that we can...
Yeah, but that's different. That's different.
Protect.
What I'm asking you is something that already exists. That's different than protecting the future. So these NDOs exist now, so there can be analysis as to whether or not you believe that that's overreach now. I'm not talking about something speculative in the future.
Okay, I understand your question, and without knowing specific laws, well, specific ordinances that have been enacted by cities, I wouldn't say that it is or has happened now.
Tucker enacted one that provides non-discrimination for those who are LGBTQ. Would you consider that to be an example of overreach?
Well, first of all, I'm not an attorney, as you may know.
That's fine.
And could you read me or cite me exactly what the law says?
It prohibits any discrimination on the basis of sexuality, effectively. So is that an example of something that you think would be overreach or no?
Have they passed some of the same laws to protect other individuals or other faiths or other entities? Have they passed those same laws?
I'm not sure that I understand your question.
Okay, they've passed a specific law to protect a specific group. Is that correct? Is that what you're saying?
They have passed a law to prohibit discrimination on the basis of being lesbian, gay, bisexual, trans, or queer. So my question to you is very simple. Would that be an example of something that you would consider to be overreach? Yes or no?
Well, first of all, I think the laws that are on the books are already there to protect individuals that are LGBTQ. So why would you pass another bill or another ordinance? Because if it's a city, it's an ordinance, correct?
Yes.
Okay.
All right. Thanks.
So is that overreach? Passing another bill to overreach and pass a bill to protect, say, regardless of what the group is, but not include other groups in that same protection? Are you just singling out one class of individuals to protect at the exclusion of others? If that be the case, in my personal opinion, not a legal opinion, but in my personal opinion, that would be an overreach, because why would you pass a law specific to any group protecting but excludes other groups? Does that make sense? And that's why I'm asking.
I hear your answer.
Okay.
And that's what I was asking for instead of lots of questions. So
okay.
Thank you.
All right. Well, that was my answer. So I'm asking that that you recommend passage of this bill as it mirrors the federal legislation, which I feel, in my humble opinion, is measured, fair, and balanced to protect everyone.
Thank you. No further questions. Next witness.
Thank you, and thank you for your service.
Thanks a lot. Lisa Kennemore.
Good afternoon, almost evening, Mr. Chair. Thank you, and thank you, members of the committee. I am not going to talk long because everything that has been said, I'm in agreement. I am here in support of Senate Bill 36, and as I look through the Senate bill as well as a federal RFRA, there is similarity pretty much throughout the entire bill. So I asked the committee to really consider passing this as is, with nothing more, nothing less, and nothing else added, so that we may have the protections that we deserve in this state. And and that's it. Thank you very much for being here.
Thank you. Any questions? All right. Appreciate your testimony. Next question, or next witness, Michael Lancaster.
Good afternoon, everybody, committee, Mr. Chairman. Thank you for having me. Thank you for your time. I think we're almost at the end, I hope. But anyway, my name is Michael Lancaster. I'm here representing the Frederick Douglass Foundation. I'm the state president. And I just want to start off by just saying, I haven't always known what I believed. I was born Catholic, I was raised Baptist, and I lived pretty much any way I wanted to in between. It wasn't until I got to college that my religious faith or my ideals became solidified, and I became established in what I believed. At the University of Virginia, you might see me preaching on the street corner. You might see me fasting one of my many expensive meal plan meals, or even getting baptized in the UVA pool in front of many other different believers. Those are my experiences. Years later, I would move to South Africa and start a school. And there, as a teacher and a missionary, I felt free to stand on my religious convictions. In South Africa, maybe because of apartheid, whether you were in the majority or the minority, your religious beliefs, your faith, your expression of speech was very much protected. So I never stood in fear of what I publicly said or what I lived out amongst the people there. But then I would come back home to America, and those assurances weren't so strong. We've already referenced Chike at Georgia Gwinnett College. We've referenced Chief Cochran in the city of Atlanta. When I've seen those examples, I realize that my religious beliefs may not necessarily be protected. I'm pretty much one of the most humble, nicest, kind gentlemen you might meet. But because I believe that life should be protected in the womb, people would label me a woman hater or a person who assaults women's rights. Because I believe that there are benefits to traditional marriage, people would label me a violent person or bigot or one of these kinds of things. Because I believe a biblical Christian life lived out, people would label me some kind of Christian nationalist or Christian terrorist. When my beliefs are characterized in these ways, how could you not pass a RFRA? Because what would stop any government from intervening or enacting some kind of action when you characterize a person's beliefs that way? So I just want to stand in support because, as I said, I represent the Frederick Douglass Foundation, and men like Frederick Douglass and women like Harriet Tubman and other abolitionists, they stood strong in the midst of oppression. The prevailing faith at the time was that slavery was supported by the Bible. These men and women stood up against that. They exercised their faith and their religious beliefs to say that there was a different way. They were men and women of the gospel themselves. And so I would just encourage you to continue to exercise or promote that kind of free society that we live in. There are always going to be disagreements. There are always going to be people who don't, who let feelings get in the way one way or the other. None of us like everything that is expressed or lived out in a free society. But because we live in a free society, because we champion the ideals of freedom and liberty, I would ask that you pass this bill to ensure that people like me would never have to worry about my government and the state that I love and live in would ever interfere in my right to express and live out what I believe. Thank you so much.
Thank you. Any questions? Thanks for your testimony. Chelsea Thompson.
Thank you, Chairman, members of the committee. So my name is Chelsea Thompson. I'm General Counsel for Frontline, and we stand in support of SB 36. So I just want to start, I think, too, by kind of sharing an example. We held a conference back in, I guess it was January, February timeframe, and I kind of asked for a show of hands. I was on a RFRA panel, and this big group of wonderful people that were very knowledgeable on RFRA across the country, and we asked for kind of a show of hands and understanding of what their constitutional free exercise rights look like, right, when it comes to religion. And we heard audible gasps across the room when they realized that their rights when it comes to state and local government are analyzed under a rational basis test. And so many of us know, and especially here on this committee, that the test is most differential when it comes to rational basis to the government, right? Which means that the government often wins. And under this test, the burden of proof also is not on the government, but rather on the party bringing the claim, right? So they have to show this, right, and prove their rights according to that, as opposed to under a strict scrutiny test, right, a compelling state interest. And so to clarify some points that have been made regarding rights, this is not giving the church any rights, as you guys probably are aware. Right, it's rather preventing government infringement on those rights that the 1997 Smith case and the 1997 Flores case limited, right, with our state and local government exercise rights to rational basis. And so this bill merely, this is what we argue, restores the scrutiny level to compelling state interest, as has been said today. I just want to clarify as well that, as others have mentioned, just because someone cites a RFRA claim does not mean that they prevail on a RFRA claim. So many cases were mentioned where parties have brought a RFRA claim as opposed to whether they actually won on the claim. And also to get Representative Evans, I do appreciate your desire to kind of see facts, right, and cases and the case law, especially as a fellow attorney. And so I'm happy to provide a list to you of many cases that show support for RFRA that have been brought across the country under a RFRA claim. And so just want to clarify, as others have mentioned too, that this does not deal with discrimination of a private citizen, right? So an individual on individual. This is strictly and very specific government infringement. And so there are several states that provide kind of a RFRA in action example that's mostly seen through case law. And we also oppose amendments to the current RFRA. We support the more moderate version of the RFRA that we currently have in SB 36. So we just asked for a favorable vote today, and we thank you so much for your support.
Thank you. Any questions? Thanks for your testimony.
Thank you.
All right, we've had 28 witnesses, I think. If anybody's counting, it might be one or two off, but I have down my final witness is Taylor Hawkins. But before I call him up, has anybody else not been heard who wants to be heard? All right, Taylor Hawkins, final witness. And we will give Senator Setzler an opportunity to respond at the end.
Thank you, Mr. Chairman. Thank you, members of the committee, for sitting through what has been certainly a long afternoon. Very much appreciate your willingness to dive into this issue and the details as well. My name is Taylor Hawkins, as he mentioned. I do represent First Amendment Partnership, same organization that my good friend Lance Kinzer is a part of. But I just wanted to make one brief point real quick before turning it back over to Senator Setzler. It's really exciting, personally, to see our state finally in a position to pass a bill and finish the drill on that has been waiting in the wings for over several decades now. And I find it very sad that on this very popular and nationally speaking bipartisan issue in past years that has been so grossly mischaracterized here. Frankly, however, I do think that it's good that opposition to this bill, generally speaking, has so mischaracterized and caricatured their perspective of the bill, because it highlights that much of the opposition is not actually based on the content of the bill before you, but on politically charged narratives. And I do recognize that that many of those behind those narratives do have good motivations. I recognize that. I respect their motivations. I think many of them are very positively motivated. However, other states have been able to dispense with these narratives in recent years, and as I mentioned, pass this legislation on a bipartisan way. And I do trust that our state can do the same. The opposition has mentioned, I believe, some things that highlight the need for this bill. They have highlighted the intolerance that many can have of those who don't share their personal, deeply held beliefs. And the question is, if people who hold intolerant views of other religions take control of government entities, whether at a state, a county, a city level, the question is what protections exist for the citizen, especially for the minorities who are definitionally not represented in the political majority. What protections exist for them against actions that may be burdensome? Without RFRA, the emperor has no clothes. Those protections are threadbare. They're virtually non-existent, as we've already discussed. That is, they have the basis of, if that law is facially neutral and generally applicable, then their case is dismissed. They don't even get a day in court. They have no legal recourse. And that is a standard which a bipartisan Congress recognized virtually immediately at post-1990 as being utterly insufficient to provide the necessary protections for a fundamental right. So what the opposition is saying, that, quote, because there are people I don't agree with, I'm scared of their rights being protected. With respect, I would suggest that that position is indistinguishable from the intolerance that these protections for fundamental freedoms exist to safeguard against. RFRA is by no means a get-out-of-jail-free card for those who claim that their religious freedom has been violated. It is an equal protection for all Georgians against specifically government action which may place a burden on their deeply held religious beliefs. It fundamentally applies across a broad range of cases. Representative Holcomb, to your point exactly, what things may happen or that are not covered by this bill or that this bill would change. The answer is until those circumstances come up, for instance, the Muslim lady in Florida and in other cases, children in K-12 educational settings and folks of minority religious viewpoints in the military, until those cases are brought forward, we don't really know in what ways individual actions by government entities may burden religious freedom. That's the beauty of this law, is that it's a fair and neutral balancing test to be applied with regard to the specifics of those circumstances. The beauty of this bill is that it changes that incentive structure that exists currently and carefully balances it slightly in favor of the citizen so that the tyranny that we have seen across the ages in other nations and even sometimes in politically weaponized areas of this country, whatever that looks like specifically on the ground, this bill changes that incentive structure to make sure that government entities which may severely limit or impact a citizen's free exercise, it changes it in favor of that citizen so that they do get their day in court, they do get a recourse, and their fundamental constitutional rights can be protected. So that would just urge a due pass measure and thank heartily this committee for their long-standing and long-suffering nature today and consideration of all the views on this subject. Thank you, Mr. Chairman.
Thanks, Mr. Hawkins. Any questions for Mr. Hawkins? And look, you know, trials go a week, 2 weeks. I mean, we've done 3 hours today, so you got a bunch of folks on this committee who are used to taking in two sides on stuff. So it's not long suffering for us. Thanks for your testimony.
Really appreciate it, Mr. Chairman.
All right, Senator Setzler and Mr. Kinzer, are y'all ready to close us out?
Thank you, Mr. Chairman, members of the committee. Appreciate the time of the committee and the attention of the members. I will, I guess, as a sort of a transition, perhaps apologize to committee members. We didn't perhaps educate more, and as we came into this. In my initial presentation, I talked about just briefly mentioned Smith, talked about the Bernie case in Texas in 1997. I didn't take 10 minutes of going through all this, but perhaps just to address that, it was alluded to by some of the speakers earlier. Again, the Employment Division v. Smith decision, 1990, kind of overturned decades of jurisprudence that said strict scrutiny protection is given to free exercise. That goes back to Yoder. And when that happened in 1990, Congress saw the issue. 1993, passed federal RFRA to elevate free exercise to a strict scrutiny level protection. It was in 1997, again, the Bernie v. Flores case that ruled, it was a federalism case, kind of a surprise to some, that said, the federal RFRA does do its job with respect to protecting people from federal government actions, but it does not protect people from state or local government actions. State legislatures and courts have got to put that in place. That's like the foot stomp test question. I mean, we probably don't need to go any further than this committee to that is clearly understood by every committee member. And I don't want to say that in a way that's in any way disparaging of anybody. This is a lot to take in. And it is not common in our federalist system for that to be the case. But it is indisputably the case that with respect to protecting free exercise, of a citizen with respect to state and local governments, the Bernie case says very clearly, states have to act and only state action can protect those interests. That creates the hole that this bill addresses. This bill exists for one reason, for that specific legal hole. Mr. Chairman, we did talk about a couple cases in Georgia. Again, I will pronounce it differently than others, but the Azugbadam case out of Georgia Gannett, as we discussed earlier, there were two prongs that were argued. One prong went up on speech, but the free exercise prong was indisputably recognized by our current Attorney General that the free exercise claim of individuals under state law has rational basis protection only. The fact that redress was sought and achieved under speech is important, and I'm happy for the gentleman. But it's indisputable before this committee that that Azugbadam case shows it's on point, specifically as Mr. Kinzer alluded to, as our Attorney General put in his opinion, rational basis is the only protection one gets. And I think that's really the issue we bring before this committee is one, it's a matter of law, not a matter of opinion or intentions or those things. It's a matter of law. One question that was brought by, or spoken to by some members of the committee that I wanted to speak to, a reference to the local non-discrimination ordinances. Representative Holcomb specifically asked that a couple times. As I said earlier in our introduction, and I sort of said a couple times through our presentation, this bill seeks to leave those in place. This bill does not seek to wipe those out. Some states have specific preemption that prohibit those from being in place. This bill in no way does that. This bill in no way is intended to do that. It's, as one of the laymen presenting here said, hey, silence is uncertainty. I appreciate the sentiment, but again, as a matter of law, that's not the case. This bill specifically leaves in place those 18 ordinances. This bill is intended to do that. It is drafted specifically to leave those in place and not touch them. Full stop. And I'm glad to take questions on that point. What it does do, though, one thing that was alluded to earlier was there's no carve out for them. This bill does not say that if there's a municipality that has a non-discrimination ordinance, that a free exercise claim offered under a state RFRA law has no force and effect. It's exempted from that. What that would mean is that a local non-discrimination ordinance, if we should pass a law that did that, not our bill, but if we were to carve out any allegation of discrimination, no matter how de minimis or minor, would automatically cancel any religious claim, no matter how significant. That's the issue. That's why a carve-out for non-discrimination doesn't, quote, authorize discrimination, but what it does is it exempts any allegation of discrimination, no matter how minor, from a major impact on religious rights versus, which takes, it's this premise of exemptions. This is not an exemption bill. One of the persons said, this is an exemption bill. This provides, in fact, one of our members said that's just factually not true. This is the balancing test bill. This provides the appropriate weight, what I believe the appropriate weight, and what our legal history in our nation would assign as the appropriate weight for a free exercise claim, which is strict scrutiny. And when it encounters those local NDAs, they're weighed appropriately. And in many circumstances, if you look at the legal history of RFRA, the compelling governmental interest is on the side of the government. In the case of a local municipality that has those NDAs, that compelling interest is raised to an even higher weight because specific efforts have been taken by those local entities to provide more weight there for that interest. But even if that interest, that compelling interest, was cited with respect to the LGBTQ interest or whatever the local ordinance addresses, it still should be true that if that interest wins, that if a person of faith can be accommodated in some reasonable means, least restrictive means possible, RFRA would allow and provide that the religious interest be accommodated in as reasonable way as it could be provided. Without that, there is no burden of proof on the government to do anything. They can simply wipe it clean and ignore it and move on. See, it's the least restrictive means possible test that really is the importance of RFRA. Not that it makes that the person of faith wins, but that when the government interest wins, if some accommodation can be made, the government does that. It's the delicateness of this that's really the importance of it. So even in these which is specifically why, we use this term RFRA travel. The RFRA bill we've proposed travels very well, because in certain communities where a greater weight is given to a certain interest, it recognizes that and doesn't seek to wipe it clean. Now, it's a separate conversation. Many people say, well, we need to have a statewide, civil rights ordinance that grants rights. That's a separate policy discussion. And I think it's fair to say that it's separate. I think the analogy, Mr. Chairman, I would share is that if this were a bill that went into the, for example, if this were an education bill that went into the QBE funding formula and said, let's lower the classroom size for special ed students. We think that needs to be adjusted. Well, if the answer was we'll address the classroom size for special ed students, but we have to do that only if we have comprehensive reform to the QBE funding formula. We really need QBE reform. Tweaking classroom size for special ed students should not require fundamental QBE reform to pass that. This is a very, very narrow circumstance. It is exactly as Representative Evans said. It's filling a hole. The issue of comprehensive civil rights reform is a separate question that is outside of the scope of this, and I'm simply seeking to fill this hole that we've addressed with the delicate care that this bill seeks to take, which is that middle ground position. It doesn't concede, doesn't go after it. It's right down the center and allows those local ordinances to exist in every case and recognizes the diversity across our communities. And we have a very diverse state. One of the most diverse states, if you really think about our state, how it operates. Again, as Mr. Hawkins said earlier, I would highlight the words of Rabbi Bernstein. He was speaking against the bill. He says, protection is needed for minority faiths. I agree with him. I just would take the opposite conclusion. I think because of that, we need this bill. I think the sentiment is right. The sentiment of many of the speakers was right. But their point is, it actually, to me, is convincing why this bill is needed, not to the contrary. One thing was raised, unfortunately, by my friends of the ACLU. They cited examples of RFRA being used as a defense for child molestation. Well, as one of the layman speakers said earlier, it didn't carry. When RFRA can be used to make all kinds of wild allegations. All kinds of allegations are made within our legal system, but RFRA does not substantiate those, and never has. Mr. Corman spoke, appreciate his very measured presentation, cited some specific examples as a person of the Jewish faith, that he had some specific concerns. And again, as he said, I think as Mr. Person said, don't have to have a fire in your house, don't have to have a history of your house burning down to have home insurance. You need to have appropriate protections. And that's what this bill simply seeks to do. Mr. Chairman, glad to take any final questions from members. I do appreciate the indulgence of the committee and the indulgence of the chair.
I'll just very quickly say, I do think on the possible exemption of NDOs that the view that non-discrimination laws should always trump religious liberty, which I think is functionally the effect of an amendment to that extent, is a view that not even a single member of the U.S. Supreme Court holds that view, and we can show that very simply by looking at two relatively recent cases. Hosanna Tabor Evangelical Lutheran Church versus the EEOC, which was a unanimous U.S. Supreme Court opinion that specifically rejected the argument that federal non-discrimination laws can be used to trump religious association decisions. And it was actually Justice Kagan who joined with Justice Alito in writing a very good concurrence showing exactly what the interaction between free exercise and non-discrimination laws should be. And then Fulton v. Philadelphia, another more recent 9-0 opinion, which again, the U.S. Supreme Court said that a non-discrimination ordinance couldn't be allowed in that instance to trump the religious liberty rights of Catholic charities. And so my point is just to say that our view, which is that you should apply these tests, you should apply these standards, even in the context of non-discrimination laws, is not an unusual position. It's not an extreme position. It's a position that's repeatedly been agreed to by really every member of the U.S. Supreme Court. You might
reach a different result on how the balancing test applies in the case, but the notion that it shouldn't be balanced is incorrect. And the final thing I do want to say, because there were some statements made about the application of RFRA, and I want to be a little bit more specific. The Indiana case was Blattert v. State of Indiana. The trial court in that case granted the state's motion to exclude the use of RFRA as a defense at trial. The Indiana Court of Appeals agreed with the trial court. No RFRA defense was allowed in that case, and Mr. Blattert received a 13-year sentence to prison. The New Mexico case, which was mentioned, was State of New Mexico v. Bent. That was a criminal sexual conduct case. That was not a RFRA case. RFRA was never raised in that case. Mr. Bent brought an ineffective assistance of counsel claim against his attorney, saying that he should have raised a RFRA defense, and his ineffective assistance of counsel claim was denied. The idea that the Department of Labor was unable to investigate child labor law abuse, that was Perez v. Paragon Contractors. In that case, it was an administrative procedure at the investigative stage. A federal court judge said the information that you're asking for in discovery, which there was a claim made that RFRA protected that, the district court judge said, under the least restrictive means test, I believe the government has other ways to obtain these exact same records, and so they should pursue those ways. If they can't receive them, they can come back and renew their request for discovery. Ultimately, the Department of Labor obtained the information it needed, successfully brought an enforcement action against the defendant, who was fined almost $2 million. There was talk about a case where a police officer would not provide services for a meeting at a mosque. That was Fields v. City of Tulsa. This was not a RFRA case. In fact, leave to amend the complaint to add a RFRA claim was denied by the trial court judge in that case. The access to health care cases, the most prominent ones are U.S. Supreme Court opinions, some of which did involve RFRA, but all which relied upon least restrictive means. The fact that everyone still had the opportunity to receive the health care services that they wanted, the government had a mechanism to make those services available without basically co-opting a group like the Little Sisters of the Poor and forcing them to facilitate. And then finally, I'll just say the South Carolina adoption cases, that was Madonna v. U.S. Department of Health and Human Services and Rogers v. U.S. Department of Health and Human Services. You can look those up. Neither of those cases were RFRA cases. They were decided on Establishment Clause grounds. They were decided post the 9-0 Fulton opinion, which I mentioned previously, in which the U.S. Supreme Court said that you can't use anti-discrimination ordinances or other laws to restrict the ability of faith-based adoption and foster agencies to contract with the state. This litigation was essentially another bite at the apple at that, but those were not RFRA cases. I say that because I do feel like some of those examples are relatively inflammatory when you don't understand the actual context and what happened in those cases. And I think what all of these things show, the fact that the examples that were brought are all things that can relatively easily be responded to if you look at the cases, is simply this: 30 plus years of federal RFRA statutes around the country. And if RFRA statutes were providing a generalized ability to engage in invidious discrimination in the face of federal anti-discrimination law, local ordinances, or state anti-discrimination law, believe me, we would be hearing about those cases with specificity here today before this committee. Instead, we get a bunch of cases that in many instances aren't RFRA cases at all, and where they are cases typically where the plaintiffs lost, or where we think they won, as in the healthcare cases, for very good reasons. So I'll conclude with that, and I appreciate the committee's time.
Thank you, Mr. Kinzer, and don't worry, this committee's got a very good filter, but you went through and cleared that up. We have a question from Chairman Smith.
Thank you. Appreciate that, Mr. Chairman. I should have asked this earlier. The 18 locations in our state that already have some kind of ordinance that we've spoke of earlier, where does that protect them within the bill? Or where would it not have, where do we read that it doesn't affect those existing 18 jurisdictions?
It doesn't need to be stated in the bill. This does not engage those. Those would run parallel to this. So those stay in place. They have full force and effect.
They're not preempted.
They're not preempted.
Okay.
The only way this bill would address those if we tried to preempt them, and we specifically chose to not preempt them, we leave them in place. So in those communities, that those interests are elevated and have greater weight in the balancing test. We think that's appropriate.
Okay. Mr. Chairman, that's appropriate time. I got a motion.
We do have another question. Representative Holcomb.
Thank you, Mr. Chairman. One of the things that I'm wrestling with is with respect to the federal RFRA, which I see that this bill largely maps that. We had in place the 1964 Civil Rights Act for almost 30 years before that was enacted, as well as other protections. And then my sense is that in many of the states where there are RFRAs, I haven't done the research on this, but two of the states that were cited in testimony were Arizona and Texas. And a quick look shows that they actually have state civil rights statutes. So I'm not fully convinced that this debate is should be divorced in terms of the interplay between the protection of civil liberties and the protection of religious freedom, which you're seeking to achieve. So my question is, of those states that have RFRA, can you tell us how many do not have a complementing state civil rights statute?
There are 3 states that do not have state civil rights statutes. Okay, Georgia's, as we discussed earlier, Georgia being one of them, recognizes that the whole panoply of rights and issues that are in play in the Civil Rights Act of '64, Fair Housing '68, and subsequent fair housing, all of those have full protections in our federal courts. Federal law has full applicability to every single circumstance, and citizens have full, complete protections there. If free exercise with respect to state and local governments were like those, had those protections, we wouldn't have this bill because we'd already have full protections. This is specifically a hole in the law, that citizens have no protection from state and local governments with respect to free exercise only. Speech, assembly, press, all of those get those protections. But free exercise only, with respect to state and local governments, they are the hole in all of this. So in all of the every single circumstance, you have the same protections in Georgia at the federal level that other states have at the federal level, and it is the complete range of rights. Now, if we as a state wanted to grant the exact same rights at the state level, we would have a circumstance where, well, I could go federal, I could go state, I could go to try to shop for venues, and you could create a circumstance where you've got really overlapping jurisdiction, and there could be chaos and uncertainty. We have one system for these rights, and it's the very substantial federal system, which I believe, I think if you talk to attorneys, your rights are protected at the federal level in a very robust way. Procedurally, you get access to attorney's fees if you prevail on the merits. So Georgia's taken the tack that those provide complete protections, and there's not a need for a state level ordinance that covers the exact same things. Some states have wanted to go beyond and provide protections beyond what the federal statute offers, and that's a substantive reason a state might choose a state level law. But the only thing that covers is additional things that states believe federal law does not provide. This bill is the very limited subset of circumstances, the hole in the law. Free exercise is not protected from state and local governments at all. That's why we have this bill. It's plugging the hole.
Okay. Let me ask a different question, if I may, which is recognizing your statement in terms of clear legislative intent that your goal is not to displace the existing non-discrimination ordinances. If this were passed and enacted, and then a local government enacted a non-discrimination ordinance, would that survive?
Yeah, we could have 50 municipalities. We could have 537 cities. 519 additional cities pass local non-discrimination ordinances, and they'd have full force and effect. There's no need for effective dates. It's because those entities have full powers under our Constitution for home rule and to enact the ordinance they put in place. And I think they put a lot of thought to them. And we heard one of the witnesses earlier talk about it took them a couple years to think through how they did this. I don't think they take it lightly. I would anticipate there will be additional municipalities or perhaps counties that do that. We're not seeking to stop them. We're not saying anything before this date or after. We're touching none of that. All we're doing is setting up a structure that says free exercise is protected. Whatever happens in other parts of law can happen, but free exercise shouldn't be down here. It should get full protections because it is the hole that needs to be plugged.
Just to provide real quick clarity, there are 2 other states that don't have comprehensive civil rights laws, Mississippi and Alabama. Both of those states do have RFRAs. And then I think the key on the NDOs is that unlike some states like Tennessee, Arkansas, and Utah that have specifically said you can't have local ordinances more expansive than the state, in preempted, this doesn't do that, but it also doesn't carve them out from the effect of RFRA. It says that those NDOs exist, they continue to operate, they continue to be enforced, but a citizen could use RFRA as a defense, and the compelling state interest balancing test would apply. So that's the effect of this bill on past or future NDOs, were it to pass as drafted.
The devastating effect of a, quote, non-discrimination clause, even though it sounds good, what the legal effect is any allegation of discrimination would exempt someone on the other side of a question from raising a religious claim, which would mean a relatively minor, slightly more than de minimis discrimination allegation or interest wipes out religious interest of significant substance. Because it becomes an exemption. This bill specifically is not an exemption. This is not an exemption bill. It's a balancing test bill because the fact-specific circumstances are they're so broad. We need to have a judicial standard, not exemptions. You can't. The war of exemption is a war that never ends. We're not trying to do any of that. This is simply a balancing test.
Thanks. Representative Evans.
Thank you, Mr. Chairman. Senator, I understand you saying that it's not your intent to preempt the local ordinances, but my understanding of how the hierarchy of laws work is the federal government, for example, doesn't have to say that it's not. If the federal government is silent about preemption and it covers an area that we try to cover as a state, we're preempted. Same thing here. If we don't say we're not preempting local law, then just by operation of law we do. It like silence. And can you tell me with your tell me where I'm going to find authority for that not being true?
Because you have certain inherent home rule powers, and our cities and counties are operating with their home rule powers. Some are constitutional, some are statutory, but their home rule powers exist, and they're enacting these ordinances pursuant to those powers. We're not addressing those home rule powers at all in this bill. All we're simply saying is as an individual has there's a duty on government to apply this standard when a free exercise claim comes into contact with any power of government, whether it's something that's in non-discrimination ordinance, whether it's just a decision of the mayor, whether it's a decision of the police. I mean, at any level, those powers exist and are robust and have strong protections in our Constitution and in our laws. So this simply says when this whole body of authority comes into contact with a religious claim, there's a series of tests that have to be applied. Is it generally applicable? Is it targeted at someone? Mm-hmm. And then if it's a generally applicable law, rule, or ordinance or decision, and someone alleges a religious claim, is it a compelling interest? If so, then it doesn't. But by doing this, it relates to religious claims. It doesn't relate to the authority of the government in any way. Does that answer your question?
Well, I'm not sure, but if your intent is not to preempt, you wouldn't mind us putting an amendment to make that clear, if that's not your intention, right?
Well, it depends on.
And if so, why?
Well, I mean,
if it's not your intention.
What we can't do is say that a protection. We can't create an exemption where an allegation of discrimination is completely carved out. I mean, philosophically, we started this bill from the perspective of we're trying to mirror federal language. So I'm not speaking against you, Representative. I'm just saying our charge from the governor was mirror federal language. if we had crafted a kind of a de novo state law that put in a compelling interest test, then we could have crafted some things that maybe address some of those questions. We've tried to follow the federal language so that it's on its face. That's what it is. That's why I don't believe it's necessary. Governor's Council doesn't believe it's necessary. I don't know that there's a compelling reason to show that it is. Can you show me where that is? I'm not sure that we've not. No one's raised that before because I don't think there's any. It's a novel question. Would you speak to that, Lance?
The only thing I was going to say is that I think one way to think about this is that this adds the RFRA test to every state statute, every local ordinance, everything that the government has done now falls under this standard. And so saying that, local ordinances don't cease to exist would kind of be like saying the rest of the statute code of the state of Georgia doesn't cease to exist because we've passed this. What we wouldn't be willing to agree to is to say that local non-discrimination ordinances have a different standard than the RFRA standard apply to them. But language that just says this law continues to, these local non-discrimination ordinances that continue to exist really is superfluous because this law applies to everything in the Georgia statutes. It applies to everything at the local level, and it does that without just by the terms of the test itself. So that's the way I would try to describe it.
Thank you, and this is just a follow-up to Representative Evans' question. I think there was a mention of home rule. So while I understand home rule that local counties can pass ordinances, as long as it's not preempted by the state. If this is silent, it can be not maybe expressly preempted, but it can be preempted by implication. So why not put, and I'm sorry, so why not put a specific exception in the bill so that, as you guys may actually referenced earlier, the belt and suspenders?
Well, I think the only thing that this would arguably preempt would be a local unit of government passing an ordinance and saying, if a religious liberty claim is made vis-a-vis this ordinance, the court should apply rational basis. That would be preempted by this. But the substance of the law itself wouldn't be preempted. It could continue to be enforced. And so I think language that said that local ordinances continue to be enforced wouldn't make any more sense than just adding something to this that says the Georgia statute books and all ordinance, no Georgia statute or ordinance passed by a local unit of government is abrogated, is preempted by this. Then we would want clarifying language, but the standard established in this bill does apply to any conflicts around religious liberty relating to those statutes or ordinances.
And my concern is,
and that's what it already does as written.
That would be so novel it would create confusion. What does this mean? Because it doesn't exist other places. So I'm not just trying to be combative. It's just not how we write laws. Is to say that this law is does not conflict with other laws. It would seem to be novel.
I appreciate your response, but we have a lot of laws that will say almost explicitly that it will not conflict.
Well, we'd say notwithstanding this code section, that has a specific meaning. We say, as I told Representative Evans, it's never been, this almost seems like a presentation of the inverse. We've never considered a non-preemption language.
Thank you, Mr. Chair, and thank you, Senator, and for all your hours of discussion on this. And I may have missed some things over the course of all these hours, but what is your position on any municipalities or counties or local governments who may in future want to pass an ordinance? So how does that interplay?
Thank you. Representative Holcomb asked the question.
Okay,
we're friendly to that.
Okay.
I would anticipate I don't know the complete history of local non-discrimination ordinances. I would anticipate that as we're bringing new cities into existence, and there are emerging sentiments across our cities, I would imagine there's going to be some number of those, and this has no impact on those. That's why I don't want to say it's effective this date. It's by being silent to that, it could let every city and county have their own flavor of that in a way that's within their home rule powers. I think what we're seeing here, though, is if they do that, current city or future city could write an ordinance, and that stands on its own. And as we elevate people's for exercise rights to where it should be, that in those municipalities, or in that county, that interest would weigh heavier than it would in a county that didn't take that action. And we're cool with that. That's why I think this is a balanced bill, because it's as you go from municipality to county, as these changes are put into place, we're comfortable with courts who see that, who would weigh those more heavily.
Just quick follow-up. I mean, if that's something you anticipate, it sort of leads back to a comment that Representative Silcox made very early on, which is, we're going to have a patchwork, and maybe it would be cleaner to add some non-discrimination to the bill itself.
Well, again, I think the point is, and I appreciate Representative Holcomb raising this earlier, a non-discrimination, and you might have missed this, a non-discrimination clause, what it would say is, if there's an ordinance that is impacted minimally, there's a tiny impact. If there's a non-discrimination clause in this, then no matter how huge the religious impact is, it's completely wiped clean. So if you had think about this. Any allegation of discrimination, no matter how minor, would completely render a religious claim as being non-applicable. It would have zero force and effect if there's an exemption. This is not an exemption, this is a balancing test bill. That is essential to understand, and that's the most important thing about this bill. Attorney Kinzer just said a minute ago, there's these 9-0 cases in the U.S. Supreme Court. A religious claim comes up against a basic civil rights claim, but by a 9-0 opinion where Justice Kagan joined Justice Alito in a case, and we can share this with you, that some claims, in fact, what's the nature of the claim in that case?
Well,
she may have missed
in that claim, it was it involved an employment discrimination claim against a religious organization. But I think what I think might be clarifying is to say that this bill does not abrogate, does not take off the books any existing non-discrimination ordinance, nor does it prohibit any locality from passing a non-discrimination ordinance. But whether it's a past non-discrimination ordinance or a future non-discrimination ordinance, if there was a claim that it was being applied by the government in a way that burdened someone's religious liberty, the court that would then weigh that based upon the test that's provided for in the bill, the strict scrutiny test. Now, what we see from places around the country is that, generally speaking, government action to prohibit discrimination is a compelling state interest. And so typically they can win those cases. There's a very, very limited number of cases where these have ever been applied in those circumstances. The one that really comes up is a wedding vendor case under the Arizona RFRA from a couple years back, where there was the ability of a person who did wedding invitations to prevail under a state RFRA. She also prevailed under some speech claims. That case now would be decided under speech grounds under 303 Creative that was decided by the U.S. Supreme Court. There's never been a case that I'm aware of where, for example, someone has prevailed on a claim saying I have a right to engage in racial discrimination because of RFRA. I'm not aware of a single case anywhere. Even the cases related to the LGBT interests are very narrow. That Arizona wedding vendor case is, I think, the example that usually gets cited because it's a state Supreme Court opinion involving a RFRA. But the notion is that the RFRA test would apply, but in candor, in most instances where you've got a local non-discrimination ordinance, it's being applied reasonably to an act of discrimination, the government entity is going to be able to show compelling state interest, least restrictive means, and they win the case. RFRA does not predetermine winners and losers. It just says use this standard in evaluating the claim.
Chairman Smith.
Mr. Chairman, could we take a 5-minute recess, stretch our legs?
I don't have any further questions, so we'll take a 5-minute recess.
Sure. Thank you, sir. I think we're talking from have an exemption. So, this statute shall not apply to other interests in these whole categories. You can have somebody, and that will make up a example. I can imagine. Pretty superficial allegation. Maybe there's pretty small interest. If you have the exemption, no matter how substantial concern exemption, it has a zero record. It's completely wiped out. What we're trying to do is give creation justice proper weight. And then if the substance of what's on the government interest, whether it's local ordinance enforcement, whether it's a public information,
phone died like an hour ago.
Statewide,
I mean, you've got a public accommodation. Boss stop pretty much covers what you want to say. We're not trying to prejudge that. We're not trying to
All right, 29 witnesses, almost 4 hours. What's the will of the committee? Chairman Smith moves to pass. It has a second.
I'd like to make an amendment.
Representative Silcox.
Yes, I'd like to make an amendment, and I believe that Brock has a copy for everybody. But it's going to be...
Mr. Perry, please give that to Mr. Kinzer and Senator Setzler also.
It's going to be at line 35. And after the words compelling governmental interest, I'd like to add the language which includes but is not limited to protecting the welfare of a child from abuse or neglect as provided by state law, and protecting persons against discrimination on any ground prohibited by federal, state, or local law. I was sent here to represent the people of the City of Atlanta, Sandy Springs, and Roswell, and I feel very firmly that I am representing their interest.
Thank you, Representative Silcox. Any second to that amendment? The amendment has been seconded. Senator Setzler, is that a friendly amendment or?
I would not consider friendly. Again, as we talked about earlier, a discrimination clause eliminates an entire category of circumstances from this careful balancing test, and essentially, I mean, it's again, this we've shown this does not discriminate, and eliminating an entire category of circumstances from a balancing test is completely changes the federal standard.
Okay, we are going to have some discussion on this. I wanted you to be able to say as author on whether it's friendly or not, and I know there may be some folks watching on line 35 of the Senate version. This amendment proposes on line 35 after governmental interest to add, which includes but is not limited to protecting the welfare of a child from abuse or neglect as provided by state law and protecting persons against discrimination and on any ground prohibited by federal, state, or local law. That is the Silcox amendment, which has been seconded. Do we have any discussion? All right, no discussion. All in favor, say aye.
Aye.
All opposed? No. Okay, it appears that the noes have it. Okay, all the ayes, please raise your hand. We have 6 ayes. Nay, please raise your hand. So it is 6-6. The author has said he opposes it, so I will not vote on that. So we have a tie on that amendment. So the amendment fails. I have an amendment which was distributed earlier. Does everybody have the amendment that GMA requested? Does anybody need a copy of that amendment? This GMA amendment is the anti-litem notice amendment, and I offer that as amendment.
Second.
It is seconded. Mr. Setzler, is that friendly or not?
Mr. Chairman, I appreciate the intent. The problem is any anti-litem notice, there's
Just a quick discussion. To me, and I, listen to all the testimony. To me, the most compelling testimony for me was the attorney that came and testified about how our current bill, Chairman's bill that we have, is a mirror to the federal statute and how we have already case law, etc., that we can look at. And so that was the most compelling statement for me, and I agree with that. And so therefore, that's why I'm voting no on both amendments. Thank you.
Table. There have been times during this meeting earlier when some of us had discussed tabling this bill, and we were told by you that you were 99% sure we were not holding a vote today. And that's why, out of respect for your desire to hear the witnesses, I did not move, and I know other members at this table did not move. So the fact that you do not break the tie in favor of a tabling motion is extremely disappointing, Mr. Chairman. Yeah, well, I will remember in the future and will not defer. I do have another amendment.
Okay.
Unless, did Chair Lady Silcox, did you have another amendment? I defer to you, and then I'll go after you.
To say that, and I'm not sure where this would go in the bill, but I would just say that this chapter does not establish or eliminate a defense to a civil or criminal action prosecution under federal, state, or local civil rights law.
Representative Kelly moved the question, called the question, Mr. Chairman, before we got into any amendments.
I did ask if there were any other amendments. Okay. And I hear that, but I want to have everybody heard out on this. So we do have another amendment which has been presented. Do we have a second to that amendment?
Representative Oliver seconded it.
Okay, it has been seconded. All right, any discussion on that amendment? All right, no discussion on the amendment. All in favor of the amendment, please say aye.
Aye.
All opposed?
No.
Okay, appears the noes have it.
Division.
Okay. All in favor of the amendment, please raise your hand. All opposed to the amendment, please raise your hand. And I take it that's not a friendly amendment. Yeah, I will leave that as is. Okay. All right, any other amendments?
Chair Lady, are you finished?
I'm finished.
I do have one, Mr. Chairman, to add at the end of line 70, after the period. Nothing in this act shall preempt any local ordinance regarding discrimination, period.
The proposed amendment has been presented and seconded. Do we have any discussion? Friendly amendment?
Mr. Chairman, again, I think it creates uncertainty in this. You know, we worked very carefully to work within the federal framework. We don't put that language in other bills. And I don't think I think it only creates uncertainty in the law. And I think without it, we have the clarity in the law we need.
All right. Any other discussion? All in favor of the amendment, please say aye.
Aye.
All opposed?
No. Division.
All right. All right. All in favor of the amendment, please raise your hand. All opposed to the amendment, please raise your hand. Okay. The amendment fails.
Mr. Chairman, for clarification, is that because you refused to vote
It's because we had a tie.
and you're not willing to break it?
And I'm asking the author if it's a friendly amendment or not. The author has said he wants to proceed without it.
All due respect, the chairman doesn't have to answer how he chooses to vote.
I think the record should be clear.
I think the record's clear.
I don't think it is.
The chair has the discretion of when he votes and when he doesn't.
He didn't say whether he was or wasn't. He just didn't say anything.
All right. Any other amendments? All right. We have the bill as amended with an adding item notice that is before the committee with no other amendments. And the question was called. So all in favor say aye.
Aye.
All opposed? No. Okay. All in favor, please raise your hand. All right. All opposed, please raise your hand. Okay. 5 in favor, 7 opposed. Okay. The bill does not pass.
Mr. Chairman.
Representative Moptahan. Beg your pardon? All right. Representative Moptahan has moved for reconsideration. Do we have a second to that motion?
Second.
Okay.
Point of order, Mr. Chairman. A motion to adjourn had already been made.
I believe Representative Moptahan did make a motion first.
There's no way that's true. I'd ask for the tape to be played back.
People have to be recognized for motions. You can't
All
just
right.
make a motion without
All
being
right.
recognized.
Representative Moptahan made a motion for reconsideration. Do we have a second?
Was he recognized?
He was recognized. Is there a second to that motion?
Second.
Okay. All in favor, say aye.
Aye.
All opposed?
No.
Okay. We will have a division. All in favor of the motion for reconsideration, please raise your right hand. All opposed? All right. We have a 6-6 tie. We have a motion for reconsideration. I will support that motion for reconsideration. And you have a motion to adjourn?
Yes, sir.
Okay. We have a motion to adjourn. Does anybody want to have?
Posture of the bill is still sitting active in committee.
Correct.
Make a motion to table.
Beg your pardon?
It's sitting still.
All right. Okay. So the motion is still in committee. We have a motion for reconsideration that has been made, and we have a motion for adjournment with the posture of the bill still in the committee, but having received a do not pass with a favorable motion for reconsideration. Okay. Or it did not pass. Yeah, an unfavorable vote. Okay.
It would, if this were, it'd still be in the breast of the committee, correct, Mr. Chairman?
Yes.
Correct.
Would it be the same, but may I ask a question?
Certainly. Representative Oliver.
You said it's still in the committee. Is it in the posture of being on the table or not?
It's the due pass recommendation is pending.
Yes. So it's in the breast of the committee. Do pass pending. Is my understanding, Mr. Chairman.
We had a reconsideration that was granted. Okay.
Clarification or
Representative
something.
Evans.
Thank you, Mr. Chairman. What is the difference between leaving in the posture of the motion still being on the table, just being reconsidered, versus if we were to move to table it? What would be the difference in how it would be treated?
You would take a motion.
Yeah, definitely a motion to table would allow the bill to be brought up at a later date.
Then I would like to withdraw, if I may be recognized, my motion to adjourn and make a motion to table.
Second.
Okay. We have a motion for reconsideration that was approved, and now we have a motion to table the bill subsequently to that. Okay. All right. All in favor of the motion to table? Or has that been seconded? I seconded. Okay. All in favor of a motion to table, please say aye. Aye. All opposed? No. All in favor of the motion to table, please raise your right hand. All opposed to the motion to table, please raise your hand. Okay. We have a tie on the motion to table. Okay.
So it fails.
Yes,
Move
correct.
to adjourn.
Meeting's adjourned.